and the appellant is in costed more than this.
Supplemented daily. First up, item number 1.
It's also directed to serve a copy on the calculator. I've already found.
Today just now I received my papers from director. Where is the copy of OA? Have you filed copy of OA?
Copy of OA is not there.
That is a standing
Counter-
order you have.
Counter copy is there and not OA.
We have passed the order saying all the pleading before the tribunal has to be passed, filed.
The Mr. Patro and standing counsel for IA and AD, Union of India, has supplied the copy of the writ petition to the Learned Counsel for the Gazetteer in court today to seek some time to go through this and stop. Though the Union of India in this writ petition has challenged the order dated 29/4/2025 passed by the Ghanaian Central Administrative Tribunal, Cutter means Cutter in original applications number 273 of 2020, 266 of 2020, and 301 of 2020. But the copies of the original applications have not been annexed to the writ petition. And counsel for the petitioner seeks some time to file the copies of such original applications. Place this matter on the council.
The shape of amendment I have to file it.
Not necessary, just file it.
Just I have. Look,
You must have copy of those
copy.
Please tell us the date.
16th.
16th. Let this matter. Not 16th, it can be either 15th or 17th.
15th.
15th of December 2025.
Please.
Item 2.
Item 2 is we sought for instruction from the railway board because they are saying that they are filing some document that the other railway organizations, other railways are accepted based on the direction of the different courts. In that regard, I sought for clarification. MSCT can be given to that effect or not. In this regard, I have sought for instruction. Let's give it 10 days time or after vacation. Any.
No, he has filed the copy of the order dated 12/11/2024, passed in some OPCAT numbers one. So it is of which tribunal?
Ernakulam bench.
And that was perhaps confirmed by the High Court or Supreme Court.
Honorable Apex Court. OPCAT is the order of Honorable High Court of Kerala, man.
Okay.
And 27/10/25 order is the order of Honorable Apex Court, man.
Okay.
And that has been implemented.
That has been implemented. That is. So that you are to just verify, Mr. Pari.
Yes. So I am checking for a railway board whether they are on similar footing or not, and this is applicable to Odisha also. Because we are in it.
And also that order has been implemented also, that he says.
They are saying. So. That's why I am a sought for instruction.
So
all three cases are related to the same issue.
That you can know. Your officer can say it. So
why not clarification come from the railway board?
Before winter holidays. Just
after vacation, it is better.
You have taken
one person has been given the benefit, and these persons will be deprived of such benefit, even though the order has been passed by the Honorable Supreme Court.
I am bowed down because we have gone through I have examined this and only seek for instruction. After that, let's see necessary order made.
Okay, we are placing it before vacation. We might take the instruction. The Mr. Paril and Deputy Solicitor General appearing for the petitioner submitted that after receipt of the copy of the order dated 12/11/2024, passed in OP bracket with CAT number 548 of 2015, and copy of the order dated 27/10/20. अच्छा এটা কোড
Honorable High Court of Kerala
That is
and Honorable Apex Court.
Honorable High Court of Kerala, and also a copy of the order dated 27/10/2025, passed by the Honorable Supreme Court from the Land and Council for the opposite parties, he has sought for instruction from the Railways Board to verify whether the petitioner is similarly situated like the petitioner in the said case, which was disposed of by the High Court of Kerala and by the Honorable Supreme Court, and also whether the said order has been implemented in the meantime or not, as stated by the Land and Council for the opposite parties. Place this matter on 17th of December 2025. Instruction be obtained in the meantime.
May I frame my lord? I have filed a memo on 20th October. Lord, kindly give page 1.
20th of
October, my lord. Page 1 of that memo.
Yes, we have got it.
My lord. The Lordship kindly give a glance. I am reading. Please find the enclosed here the Railway Board's letter cited under reference, wherein it was advised that it is not fit for filing SLP in Honorable Apex Court against the order dated 11/12/23 of Honorable High Court of Hyderabad in WPC number so and so, Union of India versus J. Venkataraman and so and so.
Around Hyderabad current upon Kerala count file.
My lord, except Odisha, in other zones, I have filed a series of orders, man. Along with this memo, and this memo order shows that a series of original application allowed, read dismissed. Thereafter, they have not Apex Court and implemented the same.
The Land Council for the opposite parties has also filed some filed a memo, a list of the office order issued by the other zones granting grade pay of rupees 4,600 and 4,800 under MACP to similarly placed persons. In the said order, it appears that against the order of different high courts, decisions have been taken not to approach the Honorable Supreme Court. Mr. Party shall also obtain instruction in that respect by the next day.
They want to give you special treatment. They want to give you special treatment.
They want to deprive.
The sub item 2, my lord said.
One to
This matter with WPC number 28299 of 2025 and
29319. All the three may be taken together.
May I pray all this matter on 22nd?
Yeah.
22nd.
If you take it to the while the vacation is near, you may face problem. If you have difficulty on 17, it's all right.
No, I have no difficulty. Oblige.
Item 3.
Mobile. My subject matter. This is a case of foot of duty. Petitioner was placed on foot of duty with effect from 5/10/2015. Charge sheet was issued after 2 years, 4 months.
Foot of duty was passed in view of that you have mentioned in that order, that is Rule 12(1) of Grameen Dak Sevaks Conduct and Engagement Rules 2011. You come to please Annexure 1. Annexure 1 is page number 16.
My lord,
Please come to the first, actually second subparagraph.
my lord.
And whereas, please read it. The
And
inspector of post,
Kamakhanagar subdivision has
Uh-huh.
put the said Sri Das under off duty by
this
memo
Das means the petition, right?
minor.
Uh-huh.
By memo number dated 5/10/2015 by Rule 12(1) of the Grameen Dak
Do you
Sevak.
want to see that rule?
We had similar matter yesterday, the same person.
No, that-
That's it.
My lord, this is 12(1).
Have you posted anywhere in the writ petition?
Yes, ma'am.
12(1).
But that may not be.
ଗୋଟେ ବହିଟା ଯେତେବେଳେ ଆପଣ ଗୋଟେ ପ୍ରୋଭିଜନ ଟା ଇଏ କରୁଛନ୍ତି,
ମୁଁ ଆଜ୍ଞା
normally not available. You should have quoted in one paragraph.
I have quoted my.
କୋଉଠି quote କରିଛନ୍ତି? We do not find it. What's the name?
Para 19, you have put something else.
ନର୍ମାଲ ବହି ହେଇଥିଲେ ଗୋଟେ ଅଲଗା କଥା। ଏଇ ଯୋଉ ଗ୍ରାମ ଡାକ ସେବକ ଏଗୁଡା ଦିଅନ୍ତୁ ଆମକୁ ଅଛି ତାକୁ ଖୋଜିବାକୁ। there
It is there.
ଆପଣ ଦିଅନ୍ତୁ ଆମକୁ।
Is 117.
At least you should have made a Xerox copy of
Page 117. ma'am.
Where is your original application? Where is your original application?
I am coming, madam.
Page
62, madam.
शायद अच्छी है, देखिए।
rule 12(1). Rule 12(1) kahin?
Page 115, madam.
Yes, please read it out.
The engaging authority or any authority who is the engaging authority is subordinate or any other authority empowered.
Please go slowly. Read it once again.
The engaging authority or any authority to who is the engaging authority is subordinate or any other authority empowered in that behalf by the government by general or special order may put a sabbath of duty where the disciplinary proceeding against him her is contemplated or pending. This is relevant.
This is the relevant provision.
My
Contemplating or pending?
It is contemplated.
Okay.
In your case, it is contemplating.
Then what?
In your case, it is
It
contemplated or
is
pending?
contemplated on 5/10/2000.
Okay. Then what is there? What is your case?
My lord, page 117, there was no review, my lord, for 2 years and 4 months. And page 117, instruction 2. Instruction 2. Instruction on put of duty cases on the basis of accepted recommendations by the government of the Committee of Inquiry Sahoo Committee on Extra Departmental System. What extra departmental system means? GDS, my lord. The following instructions are given below to follow while putting an EDA of duty. Roman 2, personal review by regional director. The regional director should personally review every month cases of put of duty of all EDA and issue appropriate orders in each case. Cases pending over 6 months to be brought to the notice of PMG/additional PMG. Cases put of duty pending for 6 months or more should be brought to the personal notice of the Postmaster General/additional Postmaster General, who should issue appropriate direction in this regard. Instruction on the subject should be strictly followed to dispose of disciplinary cases against delinquent EDS expeditiously to avoid delay in finalization of such cases.
What's EDA? EDA stands for?
GDS.
EDA stands for what?
Extra departmental agent. Now it is.
Sevaks are EDS.
They are not designated as Grameen Dak Sevak, GDS.
Where from we get? This is applicable to EDS.
Yes.
Whether it is
Okay,
applicable
my
to
lord,
Gram,
It
Gram
was
itself.
1990 order was there, but later on they were redesignated as GTS.
What has happened in this case?
In this case, they have issued charge sheet after 2 years, 4 months. My lord, page number 118,
No, first tell us the dates when you are put up on duty. What is the date?
5/10/2015.
Where is your date chart?
Appendix 2, my lord.
5/10. Acha, put up duty order was issued. Acha, then it was confirmed within 11 days. Okay.
Because it was by the junior officer.
Charge sheet was submitted on 26/2/2018.
My lord.
Then inquiry report was submitted in 20, and you submitted the representation to revoke the put up duty and pay the duty pay.
My lord.
That is in 2016 also.
15/1
So 7/12/2019.
My lord.
Proposed punishment order so and so fast action. Preferred appeal against the punishment order. So on. So let us say that this put of duty, what has been required to be followed, that has not been followed. That means every month it is required to be personally reviewed,
My lord,
and cases pending 6 months is to be brought. If that is your case, whether that can have any effect on the
Whether it has a bearing on
departmental proceedings finding.
different.
No, my lord, I will draw your attention to page number 118, para 3. It should be, the disciplinary action should be completed within 45 days. Specifically, page 118, my lord, para 3.
Para 3 মানে এটা হ্যাঁ একক পর্যন্ত
It is also necessary that disciplinary authority makes every effort to finalize the disciplinary proceedings and pass final order so that an EDA does not remain on put of duty for a period exceeding 45 days and not 120 days as ordered previously.
No, we are asking you a question. This provision is there. Suppose this disciplinary proceeding was not concluded within that period. You have, that is crossed 120 days, as has happened in this case. Can on that ground it would be held that this punishment which has been imposed on complying all the procedure, that punishment is illegal and that can be set aside on that ground?
My lord, punishment for punishment.
Because there is no such thing that it is held to be mandatory, and if it is not followed, then the disciplinary proceedings shall cease.
My prayer is here, my lord, only for put of duty for the period after 91 days to till issuance of charge sheet. Here I am not challenging, my lord, the dismissal order.
No, what you are challenging?
I am challenging. I am
that
asking
after 90 days, you should be treated as on duty,
my lord.
and you should be paid for that period.
Yes, that is my prayer.
Then you are not challenging the term.
That is in another read I have challenged.
Then where is that read?
That is 4 on 333. It is already dismissed, my lord.
Already
On merit?
On no at admission, my lord.
Okay.
Now you want that the put up duty period should be regularized till you are terminated, so that you
Till
get
charge sheet is issued.
charge sheet issue, so that you will get that.
My lord.
That was your prayer in the original application.
Yes.
Please show us that. Where is your original application?
Next 30.
Page 62, my lord.
Annexure 12.
Annexure 12.
Come to your relief short form. Please read it out.
My lord, page 70. For the reason that the extension of suspension off duty of the applicant without receiving the charge sheet.
5.1. No, you come to the relief short form. 8 number paragraph was on to relief short form.
71.
My lord, in view of the facts stated above, the applicant prays for following relief. In this respect, it is most respectfully submitted that a direction may be given to the respondent, particularly to the respondent number 4, to declare that the applicant be deemed on duty with effect from the 91 days of the suspension of duty, that is 3/1/2016 till 26/2/2018, when the charge sheet was issued, and thereby disburse all consequential benefits, including difference of pay and allowances and other benefits treating the said period as due.
Okay, what is the response they have submitted in the counter affidavit of this? You must have relied upon this provision which you are
My lord.
showing to us.
My lord.
Let us go to the counter affidavit.
Counter is page 92.
Now, what is the relevant paragraphs, Mr. Fari, on this is particular? That
11,
why is not entitled to get that benefit?
96, page 96. Let's see, may come come to the page 96.
Yes, 96.
Last paragraph onwards for us.
Verification of the password. No, that is in a factual aspect. He is dealing with a provision of the rules he is dealing with, that it provides that within what period, if he remains off duty, then what is to be done, and admittedly that has not been done.
Page
It is in page 98.
Page 100. Come to page 100. Para 5.
Para.
Para 5.
Okay.
Para 5, yes. Even there is no provision available in the Gramin Non-Disabled Conduct Rules which is able to display authority to treat GDS under the off duty to have been deemed on the duty of expiry of the 90 days.
There is provision. These provisions are there.
Provision are there. How can we say it? On the basis of this one, so କେତେ period ରଖିବ ତାପରେ ସେଟା କେମିତି review ହବ every month, then case pending before over these 6 months that is to be brought to the notice of so and so. Guidelines ଅଛି ଏଗୁଡା ବୋଧେ ଦେଖାଏନି counter file.
It is a fraud case. Or remember the earlier case.
Then you terminated from him from charging
that is a separate repetition. We are not on that.
It is in the time of investigating the fraud case. Suppose today he has filed five issue, then subsequently found that another issue is there, they can also proceed on the same.
Where is those things in your counter? Nothing is said.
He has been put off a duty on the basis of some accusation. Let us say there are some allegation against him for which he was put up a duty and a disciplinary proceeding was contemplated, right? So that period is to be, as per this provision, it should be within from 90 days. 90 days.
It is 45 days.
40
At a minor page 118, paragraph 3.
118. Paragraph
3, my lord.
Right. It is also necessary that disciplinary authority makes every effort to finalize the disciplinary proceeding and pass final order so that EDA does not remain on off duty for a period exceeding 45 days and not 120 days as ordered previously. So
it was explained me para 98.
98.
I'm just reading my note. Due to the consequence of the grave misconduct of the appellant, the disciplinary action under Rule 10 of Gramin.
Page number?
Page number 98.
98.
Yes.
Hold on.
And due to the commitment of grave misconduct by the applicant, disciplinary action under Rule 10 of the Gramin Dakseva Conduct and Engagement Rule 2011 was instituted against the applicant by SPU's Denkanal memo number dated 26/2/2018. The applicant received the memorandum of charges on 1/3/2018. The applicant did not submit his representation through the though he was allowed to sufficient time submit his defense. Thereafter, defense representation dated 10/9/2018 was received from the applicant, in which neither denied nor admitted the article of charges leveled against him.
Representation is not required for following the rules. It is the rule says that the authorized officer has to review it personally once somebody is put up for duty.
I mean, Daksabak issue, this CCS issue is not applicable. A special statute has been framed by the government of India.
The GDS conduct and engagement rules pointing out.
Postal Gramin
public servant. There is a special category employee of the
that rule he is pointing out.
That is the rule he is relying upon. And in page 100 you say there is no rule. You have page 100 you yourself says
I read minor.
That Gramin Tax Saver Conduct and Engagement Rule 2011. How do you say that there is no rule?
There is a rule for Gramin Tax.
There is a rule, and
there is a rule.
The rule he's trying to point out under the rule.
Yes.
The rule suggests that the authorized officer has to personally review
every month.
Every month.
It is
In the cases of
Whenever
put
you
up duty, and then after 6 months, it is to be brought to the notice of PMC, additional PMG, and obviously this is for a purpose that somebody, if you are not doing RTO rent something, why that man will be put off duty and he will be deprived of the financial, lose the financial. That is the purpose with this provision is there.
That was also clarified in para 7, the same page 100.
Yeah.
In response to the amendment in such and such, to the 4.8 way, it is submitted that applicant committed a huge fraud by way of the amalgamation of deposit and from the several accounts standing at his branch office. Subsequently, this man is action under
if he succeeds, he'll get some amount. That's all. He's not going to get back his job.
This writ petition has been filed. As per the order dated 29/11/2025, the Land and Council for the petitioner has filed the writ petition on the Land Council for the opposite parties, Union of India. Stop para. This writ petition has been filed by the petitioner Manas Ranjan Das, challenging the order dated 9/10/2025 of the annex chapter है ना?
Annex 14
of the Land and Central Administrative Tribunal Cuttack Bench Cuttack in way number 260/00123 of 2022 in dismissing the original application. It appears that the original application was filed by the petitioner with the following prayer, quote, the relief sought for. The opposite parties filed the counter affidavit, wherein paragraph no provision below 100 page 100, wherein in it is stated that there is no provision available in the Gramin Dak Sevak bracket conduct and engagement bracket ends rules 2011, that was page 100, which enable the disciplinary authority to treat a GDS under off duty to have been deemed on duty on expiry of 90 days from the date of placing him under off duty. It is further stated that due to commitment of a grace misconduct by the appellant, disciplinary action under Rule 10 of Gramin Dak Sevak bracket Conduct and Engagement Rules 2011 was instituted against the petitioner, wide so and so at page 98. The petitioner received the memorandum of charges on 1/3/2018, and he did not submit his representation, though he was allowed sufficient time to submit his defense. Ultimately, the defense representation dated 10/9/2018 was received from the petitioner, in which he neither denied nor admitted the articles of charges leveled against him. Stop. The Land and Council for the petitioner referred to the date chart, which shows that the petitioner was that on 5/10/2015, the put of duty order was issued, on 16/10/2025, put of duty order was confirmed, on 26/2/2018, the charge sheet was issued, on 12/8/2020, the inquiry report was submitted, on 15/1/2016 and 7/12/2019, the petitioner filed representation before the authorities to revoke the put off duty and pay the duty pay, and on 23/9/2020, the proposed punishment order was issued by the disciplinary authority, on 18/12/2020, the petitioner preferred the appeal against punishment order, on 3/1/2022, the order of the appellate authority dated the appellate authority upholding the proposed punishment was passed, and thereafter on 14/3/2022, way number 123 of 2022 was filed, that was challenging that punishment order.
No, my lord, this put up.
Thereafter on 14/3/2022, this original application was filed, out of which the impugned order arises. When we made a query to the Land and Council for the petitioner as to what happened to the orders passed by the disciplinary authority imposing punishment which was confirmed by the appellate authority, the Land Council submitted that in a separate original application that those orders were challenged and it was dismissed
By both CAT and
by both the Central Administrative Tribunal, so also confirmed by this court, and it has not gone to the Honorable Supreme Court.
So, my lord, just few days, 2 days.
All right, stop. The Land and Council for the petitioner has brought to the notice of this court the GDS conduct and engagement rules, particularly the rule
This is 10, rule 10 and
rule 12, which deals with put of duty. Which says that the engagement authority or any authority to which the engaging authority, engaging authority or any authority to which the engaging authority is subordinate, or any other authority empowered in that behalf by the government, by general or special order, may put a sevok of duty in two cases, and one of such cases where a disciplinary proceeding against him oblique her is contemplated or is pending. According to the Land Council for the petitioner, in the case in hand, when the disciplinary proceeding was contemplated, the petitioner was put off on duty. He has relied on the instruction of the Director General, which is appended to such rule, which indicates as follows. Quote this instruction 2(3) up to age 45. ये पढ़ने में quote कर देता हूँ, है ना? ये up to लिखिए page 1 यही कर दूँगा. मैं दो
172
to 117 119. The Land Council for the petitioner submitted that this only prayer in this application is to that the authority should have revoked put of duty in view of the specific period laid down in the provision. And there is no material on record that the regional director personally reviewed every month the put of duty case of the petitioner, or it was brought to the notice of PMG oblique additional PMG. And moreover, in view of the specific provision that the final order should be passed on an EDA. EDA ର full form କହିଲେ କ'ଣ?
Extra departmental agent.
Extra departmental
Agent.
agent.
In bracket GDS. Now they are being
Now it is କ'ଣ era?
GDS. Gramin Dark 7.
Does not remain on put of duty for a period exceeding 45 days and not 120 days. Therefore, there is a gross violation in following such procedure, and in view of such provision, the petitioner is entitled to get the relief as sought for in the before the London Central Administrative Tribunal, and the London Tribunal was just not justified in rejecting the prayer of the petitioner. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number 5. The Land Council for the Union of India accepts notice on behalf of opposite parties number 1 to 4. Extra copies of the writ petition be served on the Land Council for the Union of India. Matter be placed which after counter affidavit is when be filed in the meantime.
My lord, already have given a read copy.
You have given one copy. There are 4, so the extra copies has to be given because they have to send it to the authorities, concerned authority. They may file their individual response also. Okay.
My lord, page 56 to 61, I have already annexed, but I have brought to your kind notice.
Which one?
Page the instruction, page 56 to 61, I have already annexed.
Oh, he will type it out and return it to you. ये वही अच्छी चीज देखो तुम करे दियो नचे हाँ ठीक है yes next
Item 4.
Item 4, I am from BC, my lord. I prefer type to let the matter come after vacation.
117. You are appearing for?
Petitioner, my lord.
Mr. Senapati, Land Council for the petitioner, seeks for an adjournment after the winter holidays. Mr. Padil on Deputy Solicitor General with Mr. Milan Kumar. कहाँ ना लिखा हुआ मिस्टर पाड़ी?
Yes, item 3, Milan Kumar.
अच्छा, Milan Kumar. CGC.
CGC.
It's present. Release this matter. Second is here. Nothing is there. Now this is item number 4, Mr.
Oh, item number 4, this is a bank. We do.
Oh, अच्छा, later के चुना था. Item number 4 is the करने चला काटी जो कर. It urgent कर दो. Yes, next.
Item 5.
5.
This case, my lord. The question now involved is whether multiple revision is permissible under the same provision. Whether one revisional authority can sit in appeal over the order of the another revisional authority.
That was the question put before the, and the short facts are like this, you know.
You come to the your prayer portion in the original application. Read
Right.
it short for.
Just showcase and advisor. Then
Your prayer.
I
is to
challenge the
call
notice.
show cause notice.
I show cause notice given by the one of the general revisional authorities. Here, what has happened, Miller?
Where is that notice?
My lord, I will give you. Show cause notice you'll also will find at page 127.
Come to 127. Yes, please paste that for what purpose show cause notice has been.
I, the undersigned, in exercise of power conferred under Rule 25 of RSDS Rules Establishment Serial Number 49 of 75, have carefully gone through the revising authority's order of even number dated 26/6/2025, revision petition number 18/10/2024, submitted by Sushant Bhushan Mahanti, the ex Station Superintendent BNBR, Kharagpur Division, as also the punishment order imposed by the disciplinary authority and subsequently upheld by the appellate authority, the article charges, inquiry report, statement submitted by the witnesses during the inquiry, and also the final report submitted by the inquiry authority in the case of accident, ESC Circle, Sushant Bhushan Mahanti was removed from railway service on 17/1/2024 by the disciplinary authority on the ground that he did not inform the signal staff regarding the erroneous behavior of the part. The article of charges against this Sushant Bhushan Mahanti is that he failed to report the abnormal behavior of the point such and such indication on the panel of any of the SNT staff, signal and telecom staff of Kharagpur control. Had Sri Mahanti informed the repeated unusual behavior of the converter to this
Crossover.
Yes,
17A by B. Yes.
Yes. Thus, it is clear that the major accident of train number such and such at Bahanagar Bazar station on 2/6/2023 at about 18.56 hours, which led to the loss of close of 300 human lives, could not have been averted if Sri Mahanti would have taken timely action and informed the signal and telecom staff, but he has miserably failed in to perform his vital safety related duty. His extreme casual approach led to the humongous accident which resulted in loss of close to 300 precious human lives. Now, on going through the entire aspect of the case, I find that there are serious lapses on the part of Mahanti by not reporting the abnormal behavior of the point number 17A and B, indication at the point of SNT staff or Kharagpur control, which resulted in major accident. The punishment of the removal from service due to grievous nature of accident involving loss in lives has been imposed upon Sri Mahanti by the disciplinary authority and has also been upheld by the appellate authority. However, subsequently he has been exonerated by the revising authority, treating the intervening period as duty which is not commensurate with the gravity of the offence committed by charged officer Sri Mahanti. Sri Mahanti is advised to show cause as to why a penalty of removal from service with immediate effect in terms of the rules 6 Roman 8 at Railway Servants Disciplinary Appeal Rules and with extending 2/3 of gratuity and pension as compassionate allowance in terms of Rule 65 of the Railway Service Pension Rules 93 will not be imposed upon him from the above serious lapses.
Who is the revisional authority?
My lord, kindly turn to appellate authority's order.
The appellate authority is imposed the penalty, which was reversed by the revisional authority.
Yes.
Who is the revisional authority?
Revisional authority, I have been in the appellate authority order itself, I have been advised.
No, we just want to know whether the general manager who is given the show cause notice
is
another revisional authority.
He is as an another.
Who is the earlier revisional?
Senior DO.
Same officer or different officer?
No, different officer. Different officer.
The general manager only.
Yes.
He was also general manager.
No, he is not. He is this senior of the of that department. Senior most officer of that department. I'm just giving you the lordship order. Your lordship may kindly turn to page 119. That is the order of the appellate authority.
No, revisional authorities order.
My lord.
Earlier revisional authorities order.
No, my lord. 119, page 1.
Earlier revisional authorities
order. No, my lord. This is appellate authorities order. Here, however, you are at liberty, last line, your lordship. However, you are liberty to submit revision, if any, before the revising authority, that is, principal chief operating manager, Southeastern Railway, GRC.
Where is the order of the revisional authority exonerating you?
Yes, that I am giving. 124.
That is the order which is now sought.
Yes, that there.
120.
124. I have travelled in the ladder that is provided in the disciplinary appeal rules. The appellate authority advised me, if you want to prefer appeal revision, you prefer appeal revision before this authority. I have preferred this appeal. After examination in details, the revisional authority says there was also a CBI inquiry. I have been cited as a witness in the for the prosecution. CBI has exonerated
this. To revisional authority, that order which you are placing,
yes, sir.
That operative part having considered all aspect of the case,
yes, sir.
And to meet the ends of justice, I exonerate Sri Sushant Bhushan Mahanti,
yes, sir.
From all charges leveled against him, and I reinstate Sushant Bhushan Mahanti in railway service at his former post, that is assessed without hampering his seniority or any other benefit.
Other benefit.
The intervening period from the date he was removed from so and so to the date this order is passed should be treated as duty. So 26, so this is in your favor.
This is in my favor.
Then what happened?
Then suo motu.
Another
revising authority.
The first principle is for having same misconduct. There can't be two inquiry.
Exactly.
One inquiry has having concluded by this order 26/6/2000.
Yes.
You can't issue again so cause notice.
That is your case.
That is my
case. That second that so cause notice.
So cause notice I made out 127. And there also 10 days time was given.
It's all right. Don't do.
So that because of that alacrity, I immediately rushed to the tribunal. I said that
this is the first principle. First principle is for same punish this thing misconduct. There can't be two departmental.
Two departmental.
One department having come to a conclusion by the order of a revisional authority. Another so cause notice could not have been given for the same.
That's the
why this again the so cause notice was issued on what is
I have placed before the honorable court the entire thing. That's such a grave situation. Suo motu. This is suo motu revision. Suo motu revision, as if he is sitting in appeal about on the revisional order already passed by the same revising authority on the same provision.
Personal division. After the subsequent so-called notice was issued by the revising authority. Near the name of the revising authority.
Mahanti challenging the order passed by the Land and Central Administrative Tribunal Cutter Bench Cutter dated 12/8/2025. You should mention the order dates.
In the prayer, I go.
You have simply mentioned annexure 4. Yes, should mention wide annexure 4. Passed in OA number so and so under annexure 4. So also the order passed by the general manager, revising authority, dated 9/9/2025 under annexure 6. Stop. The
May I just clarify, my lord, about this?
The original application was filed by the petitioner with a prayer for quashing the Tokus notice number so and so, that is in page number 42, issued by the general manager, AC Railway, for the direction the opposite parties to assign duties to the petitioner.
Yes.
They filed their reply to this.
No, they have not filed. My lord, in the first instance, this was disposed of with the observation that multiple revision is permissible. That is the point.
This original application, when you filed, that was taken off and disposed of on that
Very first thing.
filed order dated 12/8/2025.
Yes, ma'am.
Acha.
But only because of this page 124, that notice was focused on page 127.
The learning tribunal at the admission stage itself.
But what is it?
Came to hold as follows in paragraph number 3, 4, and 5. Stop. The land council for the petitioner, appellate authority on जो order टा कहीं जोड़ा place करते थे.
Appellate revision.
हाँ जोड़ा अपन को exonerate करा. हाँ,
120. My lord, page 124.
The नहीं appellate authority रो आगे आसुन तापर जीवा सकती. जोड़ा अपन को
119.
119.
The learning council for the petitioner, with the attention of this court, to the order passed by the appellate authority, which is dated 10/9/2024. Wherein it was held that there was no merit for consideration of the appeal, and it was decided to uphold the punishment imposed by the disciplinary authority. In directing the removal of the petitioner from railway service with immediate effect in terms of Rule 6 (8) PIIA of Railway Servant (D and A) Rules 1968, and with extending to by 2/3 of admissible service gratuity as compassionate allowance in terms of Rule 65 of the Railway Services Pension Rules 1993.
You have that rule.
Yes, ma'am.
Give that rule, please. Give that.
Appellate authority order ଟା କେବେ କେତେ number?
ଆଜ୍ଞା 10/9/2024 next are revisional authority. First
ନାଇଁ ନାଇଁ appellate authority.
appellate authority 119.
The appellate authority, however, gave liberty to the petitioner to submit revision petition before the revising authority, that is PCOL. On PCOM oblique AC Railway oblique GRC within 45 days stop. The petitioner approached the revising authority, some principal chief operation manager, AC Railways, and the revising authority has been pleased by that order passed by the 124.
Yes, madam. Relevant person 145.
The revising authority has been pleased to hold that the punishment imposed on the petitioner was not only harsh, but the charges framed against him didn't stand, considering the CRS report and the submission of the witnesses before the inquiry committee. Accordingly, the petitioner was exonerated from all the charges leveled against him, and he was reinstated at his former post, that is SS, without hampering his seniority. He was directly to be reinstated at his former post, that is SS, without hampering his seniority or any other benefits. And the intervening period, that is from the date he was removed from railway service to the date of the order passed by the revising authority, was directed to be treated as duty. Mr. Mishra Land Council submits that after such order was passed on 26/6/2025, where is that order? So moto jota
127. 127, page 1, so cause notice, which I challenged before the trial. And thereafter, the final order has been passed on us.
The so cause notice was issued to the petitioner.
Group 25, we are wondering, the trial was reliable 25.
Yes,
The revisional authority says that no, you are exonerated.
yes.
Thereafter, the imposing authority, penalty who is supposed to impose the appointing authority, because general manager, who is a senior officer, has not agreed with his proposition.
But that is.
That's the penalty.
But under this, yes, my lord, under the same provision, multiple revision is not permission. That has been subsequent.
It's not. Where is it?
The same 25, my lord. This is 25, Rule 25. Both are under Rule 25. Both are under Rule 25. 120. Yes, my lord. 124 is also page 124. 124. Yes, my lord. First line itself. And that has been clarified in web.
Say that once Rule 25 is already
Exhausted. There is no. Yes, that is my point. And that has been clarified subsequently by the Railway Board. Your Lordship will get it on 146. Railway Service Conduct. Railway Service Disciplinary Appeal Rules. এটা ঠিক আমি জেরক্স করে দিয়েছি উপরে এটা দেখি ডিসিপ্লিনারি অ্যাপিল রুলস
Discipline and appeal rules 1963. It's the same authority. It should be over notice. I open the same book. And ultimately, on the basis of such notice, you have been
terminated under Annexure 6.
under Annexure
6 million. 9/9/2025. No discussion, nothing. He has relied upon the observation of the tribunal.
you are accepting Mr. Pari on the respect of all the opposite parties. This Eastern Railway, South Eastern Railway. Mr. Pari.
He will.
Mine is way appeal for
How done the expert?
Can I appeal for all the opposite part?
All that.
On the opposite party, expert of the petition, the South. On the land council for the parties. By the game. After the listed of the weeks. Yes.
I have sought for a interim direction, Your Lordship. Some, it may be subject to result of the case, so Annexure 6. For my satisfaction. And this point has also attended consideration by another coordinate bench of this honorable court. And there they have said that multiple division is not permissible. Again, IDRM pass korithile exoneration order. Yes, that decision is also.
senior DO.
Senior DOM. No, the senior DO. General manager is the revising authority. And thereafter, Railway Board can revise, definitely. 25A. Yes. Yes, 25A re karipari. But that will be done by the Railway Board. Yes. ଆଜ୍ଞା ଏଇଠି ଲାଷ୍ଟ ଲାଷ୍ଟ ବି ଅଛି ଲାଷ୍ଟରେ ବି ଲେଖିଛନ୍ତି conclusion ରେ before that you'll ultimate say see ratio is ଆଉଟା ଦେଲେନି ସେଟା ଦିଅ ଆଜ୍ଞା 25 rule 6 conclusion ଟା ଦେଖି ଦିଅନ୍ତୁ while considering the meaning of word ordinarily used in second proviso to rule 6 of DSA rules as given by the court, there is no cavil that the disciplinary authority has the discretion to impose penalty other than what is contained in the said proviso, but keeping in view the circumstances of each case. Further, when the additional divisional railway manager had already invoked jurisdiction vested in him in initiating slow motor revision as conferred under 25 of the RSDA rules, no second revision as initiated by the general manager is maintained. Last page conclusion. First, para 8.
That when the additional internal railway manager that is invoked, already invoked into the additional as conferred by Rule 25 Practical 1 of R.S. rules. No second revision are initially the same general manager. The master circular number 116 basic form 225
The provision टा क्या it is भी quote ହେଇଛି para 6.3 से master circular जोटा से 19 टर means 6.3 para 6.3
25 is also good. 7.2 day. 6.3.
6.3 of the judgment.
Yes.
Revision Revision is one-time exercise and there is no provision for second revision for the case. However, if the revision authority imposes a penalty where no penalty has been earlier imposed, or if it enhances the penalty, the rules provide for submission of an appeal. So that will be a regular appeal there. So here is a reverse case.
Same authority has gone it.
If we agree with you, then you are covered by that movie on that one. Movie, same office twice.
That is 300 CRP, double geopard. That is that film based on that.
You are saying fixed up a short date.
We are given. So, yes.
Next. Item 6.
Your Honor, I am on VC. May I?
Yes.
Your Honor, ମୋ client ଗୋଟେ loan ନେଇଥିଲା business loan, mortgage loan ଦେଖିକି property.
Not in Odia. Speaking in English, not in Odia.
Your Honor, my client has taken a business loan from Catholic Bank for the purpose of loading unloading business in Paradip Port. After that, business going into loss and he cannot repay the loan amount, and subsequently the account become NPA. Subsequently the Catholic Syrian Bank has transferred the loan liability to the Pegasus. Now Your Honor, Pegasus has unlawfully possessed our property. Today, my prayer, Your Honor, the mortgage property is the house. I pray for to discharge to give us the movables which are
in the movable, which are in the sealed document.
What are you challenging? That 13-4 notice at what? Position notice at demand notice what?
14 stage is already over. So possession notice that stage, after that 14 stage is also over. The
Your Honor,
has
Pass that order.
passed that order, and the direction was given in that order. Annexure 4 perhaps is the order passed by the Land and
yes, Your Honor. Yes,
Chief
Your Honor.
Judicial Magistrate Jagatsinghpur.
Your Honor, the order of the CSM, Your Honor, the order of the CSM is not properly passed. Honorable Court did not point out all the facts.
You have got the alternative remedy to challenge. If the CGM has not passed the order properly, then you have got the alternative remedy, not this court. That is.
Your Honor, this is the matter of urgency. Why I have come to the court.
Mr. Counsel, this order was passed by the London CGM on 13/11/2014. More than
Yes,
a year has passed, and you have not challenged the order before the appropriate forum, and now you are coming to this court in 2025 December and telling that there is urgency in the matter.
Your Honor, I am not challenging the order of the CSM. Here I am demanding my right to release the movables, to release the certificate, to release the important documents, which is
whatever it may be, in view of such order, if you are entitled to get any relief or get any other documents, you approach that authority in which you have got the alternative remedy and pray that these documents, etc., may be handed over, or whatever it may. Why we will entertain against this order, which is not maintainable in view of number of Supreme Court decisions.
Your Honor, actually there is a letter issued by the sub-collector Jagatsinghpur to my client, Your Honor, for the verification of the certificates. My client is
all these things you can tell in the alternate remedy.
The writ petition has been filed by so and so with a prayer with the following prayer, quote the entire. It appears that after the possession notice was issued under section 13(4) of the Surface Act, steps were also taken by the PGAS Assets Reconstruction Private Limited. That is to be made before him. That has to be specified. I have a certificate of change in business certificate. On the basis of this CGM's order, if he is entitled to get this answer, he should consider. That's all. Let us see. Approach the Chief Judicial Magistrates also in bank, this case number 68 of 2024. With a prayer for direction to appoint a court commissioner to take possession of the secured asset as described in Schedule 1 by using such force as may be necessary. and from whomsoever found in possession, and for a direction to the police authorities to render necessary help and assistance. The London CGM, Jarathimpur, passed the order on 13/11/2024. Wherein, taking into account the assertions made by the secured creditor in the miscellaneous application, which is supported by the affidavit shown by the authorized officer, the court was inclined to allow the miscellaneous application.
Then inventory one already. Sorry. Inventory. That's 13/11/24 next. That is maybe see also be not good. This part the lawyer had gone and prepare the this will be inventory. List of articles lying there, inventory of list of articles lying there.
The court also passed the order to the directing the subordinate officer, empowering the subordinate officer to break open the locks in the case and in case the asset is found to be locked, and in that eventuality he shall prepare an inventory list of the articles lying therein and shall hand over the copy of the inventory duly signed by him and the witnesses to the borrower, and another copy so signed shall be filed before this court along with a report. It is the case of the petitioners that in an arbitrary and mechanical manner, the possession has been taken over and it violates the principle of natural justice. And there is a failure to comply with Rule 8.2 of the Secured Interest Enforcement Rules 2002. Which requires that the possession of the property be taken with prior notice and after giving the occupant a reasonable opportunity to remove personal effects and therefore the order passed by the Chief Judicial Magistrate is not sustainable in the eye of law Stop. Law is well settled से जो 14 रो against जो थी alternative remedy कथा है ना? Since the alternative remedy is available so and so, we are not inclined to entertain this petition. It is open to the petitioner to avail the remedy in accordance with law. Yes.
Your Honor, may I put one point?
Next.
Item 7.
May it please your lordship. Here, my lord, the sole question which arises for consideration of this honorable court is whether an application can be rejected only on suspicion. My lords, this arises from the Foreign Contribution Regulation Act. Now, my lords, under this act, the entire mechanism is provided how to avail the foreign contribution. Now, my lords, if your lordship will see the definition of the Foreign Contribution Regulation
Who is
Act,
the other side, Ifa?
my lords, the Union of India, my lords.
Have you served a copy on this?
Yes, yes, it has been served. My lords.
Just a minute.
I'll
Just a minute. Mr. Parhi,
Yes, ma'am.
item number 7.
Yes, ma'am.
Have you received a copy of the writ petition?
In 7, we didn't have received. We didn't receive.
my lords, they have received, my lords. They have received.
When?
Yes, I'll give. I'll just.
Let me know.
Yes, it has been served. I cannot. It has been served, my lords.
No, he is not
Denying, yes.
denying to
That's
that.
right. I'm sorry that, my lords.
The service copy of that, so that.
Yes, yes.
Otherwise, no, you can give another copy so that we can take up this matter on Monday itself. There is no problem.
My lords,
So please give out another copy. Why will go into all these things? Look, the Mr. Pari, Land Counsel for the Land Deputy Solicitor General submits that he has not received the copy of the writ petition. Acha,
that is my appearance.
memo of appearance by Mr. Siddharth Roy, the land senior advocate, is filed, which is taken on record. Submit that let a copy of the writ petition be served on the land council for the union of land council for the opposite party. By tomorrow, like the
Yes.
list this matter on 8th of December. 8 you are available.
I'm
8th of December. Yes.
obliged.
Item 8.
I'm for the here the petitioner challenges the inaction of the opposite party number 1 is DRT cutter not disposing my surface application reading number 68 of 24. It has been filed in the month of March 2024.
I will move application for early hearing.
My lord,
Before primary-
it is all pleadings are over, but it is not.
But you have got that pleadings are over.
Pleadings are over, my lord. There is
Where have you said?
Page number 77, ma'am. Order dated
70?
77, last page of no.
Just Land counsel for the appellant present, land counsel for the respondent bank is present, submits that pleadings completed in the case, land counsel for this one. So, 11/2025 re till I hearing.
What happened?
Let the right there. The time was taken by the respondent.
Now, when it is fixed now?
I don't have to read. My limited pair is that my limited
Expeditious disposal, it's all right, but
all right, we just want to know that
we will
when
pass the order by the time.
passing the order that 11/11/2025, we do not know what has happened in the meantime, nor you are producing the order
That it is not disposed of. Again at them.
again at them. When it was fixed now?
Now it was fixed on 2/1/2025. I am for the bank.
2/1/26.
26, sir.
You are appearing for whom?
I am for the bank money on behalf of Mr. Thomas. I have filed the wakalatnama.
Kai wakalatnama kai?
This one.
I am appeal for the option purchaser, the opening number.
Passport.
You are for borrower.
Mine.
Auction purchaser means this Jitendra Kumar Gaur.
Yes.
Jitendra Kumar Gaur.
And you are appearing for the bank.
Yes, sir.
All right, that much. Mr. Prashant Kumar Satpathy has entered appearance for the opposite party number 6, Jitendra Kumar Gaur, by filing wakalatnama, which is taken on record. Stop. Similarly, Mr. Tuna Sahu and his associates have filed power for Orissa Gramya Bank, na?
Yes, ma'am.
Orissa Gramya Bank, which is taken on record. Stop. This red petition has been filed limited prayer for a direction to the Debts Recovery Tribunal Cutter for early disposal of essay number 68 of 2024 within a which was filed in terms of 17 bracket 5 of the Surface Act. The Learned Counsel for the petitioner drew the attention of this court to the order dated put out the pleading completely
22 10 25.
22/10/2025 of the Learned Tribunal, which indicated that the pleadings are complete. The Learned Counsel submits that since it is a essay of the year 2024 and pleadings are complete, necessary direction issued to the Land Tribunal to do the needful. Stop. The order dated 22/10/2025 is quoted here in the court present. Since the case was posted for hearing to 11/11/2025, when we made a query to the Learned Counsel for the parties as to what happened on that day, it is stated before us that the case is now posted to 1/2026 for
Yes, ma'am.
hearing. We expect that the Learned Counsel for the bank as well as the Learned Counsel for the opposite party number 6 submits that they have no objection if the aforesaid essay is disposed of at an earliest, and they will cooperate with the Learned Tribunal. Stop. In view of the prayer made and the fact that the pleadings are completed and the parties are ready to cooperate with the Learned Tribunal, we expect that this court expects that the matter will be taken up for hearing on the date fixed, and it will be disposed of at an earliest, preferably by the end of January 2025. It is made clear that 2026. It is made clear that we have not expressed any opinion on the merits of the aforesaid essay. Yes.
Item 9.
Paternal lordship, neither it is a surface or not a DRT matter, it is a single bench matter, your lordship.
Single bench matter.
I think so because it is a agricultural loan, tractor loan. Demand notice I have filed. Neither it is a surface matter because it is not.
So let the registry examine it, and the Learned Counsel for the petitioner submitted that in view of the nature of prayer made in this petition, it is a single judgment matter.
Court
Let
number
the
6,
registry examine the same and place the matter before the assigned bench.
Oblige.
We are just coming with.
Oblige.
Item 10.
Item 10. May I please your lordship? My lord, a right to property is a constitutional right under Article 300A of the Indian
What is your
Constitution.
prayer here?
My lord,
What is your prayer?
my prayer, my lord, I am ready and willing to pay all the outstanding dues.
No, what
But
notice
some
has been issued?
breathing time is necessary.
Sale notice has been issued.
My lord, so
Go
far
to
as,
the appropriate.
my lord, 1 minute kindly. So far as the facts of the case is
We will
concerned.
not go to the fact whether we will see that whether it is maintainable or not.
Yes, my lord.
So, how can you challenge a sale notice here?
My lord, that is the intimation to sale notice. Prior to that, my lord, 13(2) notice has been issued.
E-auction
the-
sale notice has been issued.
Intimation to sale.
How it will be maintainable once in view of so many cases that.
My lord, prior to that, my lord, I approached before the
Now
authority.
that stage is already gone.
Yes, my lord, I
Now
know
the only
resumption is
option,
not permissible.
only option is you have to approach the DRT.
My lord,
Yes.
without
Take that.
serving the 13(4) notice, they have issued
All these
the
things you tell them.
intimation. And my husband has in a brain stroke in the year 2024.
It appears that the sale notice has already been issued in view of so and so. It is open to the petitioner to approach this so and so disposed of. Next.
Liberty may be granted.
Yes, yes, liberty.
Liberty.
11.
Liberty.
Next.
Kitchen, how will they?
Kitchen.
Yeah.
Item number? 11. Yes, item number 11.
May I please your lordship?
Yes, land council.
My lord, I'm appearing on behalf of Haraprasad Panda, my lord. My lord,
Yes.
in this matter,
Yes.
my lord, yes, my lord. My lord, I'm appearing on behalf of Haraprasad Panda, my lord. My lord, a review petition was filed on dated 15/5/2020, my lord. But in the order, my lord, there is a condonation of 1669 days, my lord. My lord, the review petition was filed within 15 days from the date of judgment order, my lord.
The deputy registrar
My lord.
has given the that why the stamp reporter has given that why it has been counted to be 1669 days. So they have stated that the review petition was filed on 15/5/2020 without the certified copy of the judgment.
My lord.
One IA was filed for dispensing with that certified copy, and then this court passed the order in 2024, and then you filed the certified copy of the judgment on 23/12/2024, and after the period of limitation, and therefore the stamp reporting that the valid presentation was shown to be 23/12/2024, not 15/5/2020. So,
My lord, I have
so that is
IA
the,
with
the High Court rules, it was being shown.
My lord, I have filed an IA for the dispense of, but the matter was first taken on 2024, my lord.
We do not know. It is up to you. You should have moved the interim application, not sat silently. The no order has been passed on that particular application, even though it was filed in 2020. It came to the order was passed on matter was taken up on 11/12/2024, and then you filed that certified copy.
My lord.
So there is no question is that the delay that has been shown, it is rightly shown. The question is that whether the delay is to be condoned in the facts and circumstances what has happened in this case or not. Yes, what is your objection to that?
Objection has filed that.
Yeah.
There is no proper explanation for a file.
He has filed only, you see, he has filed the
And in the exemption application, he has said that the petitioner has applied for the original certified copy of the impugn judgment and undertakes to produce the same report. He has applied for it.
Okay.
Yes, Mr.
My lord.
When have you applied for certified copy of the impugn order? You have
My lord, as the matter was not taken up, along with the COVID period was prevalent during that time. My lord, that was the delay which caused. But we were, the matter which it was taken up, if it would have been taken up, we have been supplied the same copy within the fixed period, my
when
lord.
have you applied for certified copy? You are asking.
My lord, I have no instruction in this regard.
You are putting blame that it has been wrongly calculated, but it has been given that no, it is rightly calculated. The question is that whether we condone that delay or not.
My lord, I'm just stating that the IA was filed in this regard, but the matter was taken up after 2 to 3 years, my lord. And that was the only issue which has led to the problem, my lord.
30 କୋଡ଼ିଏରେ disposal 23/12 apply.
All the execution is to be filed as per that.
Certified copy of the High Court rules.
Yes, concept.
Objection that the in para 5, the bond and duty petition to explain the sufficient cause for day-to-day delay.
Certified copy That was not considered for COVID period after ultimately we adequately certified doctor within billions of so we just get the office coach since the certified doctors filed in 2024 that will be valid presentation. The general review petition I could have a date to see valid presentation of the 2024. That is why this 3 years etc. That has been shown in that way. Very big provision that also that can very even as per the I'm sorry. Council.
My lord.
I go Yes,
My lord, it's not audible.
You come to the court, I'll have to be matter.
Sir, pardon, my lord.
This matter on my council, we are hearing in the first book says that he is not audible. You should come to the court to argue the matter on 8th of December 2020. Yes.
There is a judgment of CBI court. They have explained what is honest filing. Honest filing
at best
necessary documents to be enclosed in a particular petition is not enclosed, then it will be treated as a knowledge filing. Whether it is a case of knowledge filing or it is really filed but without certified copy. But the certified copy is so essential. If it is not filed, it could be treated as a knowledge filing. That's the issue.
You see the provision, that review petition provision. How this review petition is to be filed, and suppose the review petition is not accompanying that document, particularly that document, then what would happen? And
chapter 8 1 says that the it shall be accompanied by the certified copy of judgment appeal from together.
Let us see that. Which one?
Chapter 8. Procedure before admission.
Wait.
That is then.
Yes, chapter 8.
2.1. Subject to Article 12.
पेज कितने ए वही दर्जन
पेज नंबर 17
two last line. It shall be
procedure before admission at a car to read it a letter patent appeal. We are on review.
Yeah, read it.
Every memorandum of it and every application for review or revision shall be immediately before.
Put up all choosing 3. मेरा chapter होची कितने को जन 8. It procedure before admission.
the court in which are the name of judge and municipal decree order objected or was made.
Shall be immediately removed.
The name and address of so and so, the court which shown address होला तापरे relief short for provided पढ़न कोडा आपण कहउचंदी
The court in which the name of judge municipal by which the order decree, then date on which the decree order was made. So once date of decree is there, that must be upon by the judgment. Otherwise, it cannot be verified by the stamp paper.
You see in 4 that rule 4 proviso टा देखो
Appeal or revision in which is filing of a certified copy of the judgment is dispensed with the appellant or petitioner. Case may be shall be a neatly typed copy of the
he shall file a neatly typed copy of the same certified to be true copy by the advocate presenting the appeal or the revision, right? So there is such provision. That means even if you are not filing the certified copy of the impugned judgment, but you are filing an application for dispensing with, and the court allows you the prayer, then you are to file a neatly typed copy, right? And that should be true copy attested. So then that can be so it is not that there is no such provision. So provision is there that even if you do not file the certified copy of the order or the judgment, till then the review petition cannot be dismissed on that ground. And in this case, he has filed the review petition in time with an application for dispensing with the
and the copy of the order
One
also.
copy of the order.
Suppose this interim application could have been taken in that 2000 when this COVID period, so and appropriate order could have been passed. But that, so the question of, so that is the reason why this is. However, we'll take up this matter on Monday. So let him come to the court and get through that. It will be addition.
Please.
Item 12.
Yes. What order was passed on
11/3/2022.
W15 number? Acha, dismissed for non-prosecution.
No. Writ was dismissed for non-prosecution. Now the petitioner
That was dismissed in 11/3/2022.
No.
And you filed the CM appeal in 2023.
No.
And that is how you have filed the application for condonation of delay.
No.
What period has been shown by the stamp reporter?
Stamp report 477 days.
477. You have filed your objection.
My lord, objection filed. But in this case, the petitioner taken a ground that he is conducting counsel dead. Therefore,
And see, in the writ petition, notice was issued in 2014. Readings completed. All of a sudden, the matter was listed on 11/3/2022 and it was dismissed.
And in this case, the issue should be decided. Therefore, the application should be restored.
Number so and so, this is an application for condonation of delay. After hearing the land council for the respective parties and going through the governments taken in the delay condonation application and the objection filed there too. We are inclined to condone the delay in filing the CM appeal. Accordingly, delay is condoned. Then CM appeal, the CM appeal has been filed with a prayer for recalling public setting aside the order dated 11/3/2022 passed in WPC number 32107 of 2011. It appears that the said repetition notice was issued to the opposite parties way back on 31/1/2014, and it was listed thereafter only on 11/3/2022. And since no one appeared at the time of call, the order was passed dismissing the writ petition for non-prosecution. Considering the amendments taken in the CMAPA and hearing the Land Council for the guilty parties, we are inclined to recall the order dated 11/3/2022. Accordingly, the order stands with us. The petition is restored to 5 days before the assigned bench. Yes, next.
Item 13.
May I please? I pay 1 week time to send the requisites because they have only manual transfer. The address what is mentioned in that first state.
Raise step for service of notice
Second day time again.
not taken.
May I
Requisites
submit
for
the
issue, just a minute. Requisites for issuance of notice on so and so not received. Received showing the service of so and so not. So you are for the petitioner.
Ma'am.
You take steps on the first.
Ma'am.
I'm appearing for the opposite party number 6, Millard. And this is a matter relating to promotion by way of selection.
We are not going to the merits of now. We are
Yeah, only I'm submitting that, Millard. The last order in also may see in the month of August only my senior was directed to file the requisites, but Millard, because he is enjoying the interim order, he is not coming forward, Lord. That is
waiting the interim order now. So when the interim order was passed?
That is on a year back, my lord. 10/12/24. 1 year, my lord.
10/12/24.
Yes, your lordship. Your lordship, sir, also.
What interim order was passed? Acha, there shall be stay of operation of the organ.
My lord. And because.
No, why will allow 7 days?
No, because the opposition 6 to 11, meanwhile they will transfer the address what is mentioned in the repeat center address. They have already transferred to some other places. This is only problem for us not to able to send the notice. Usually wants to
was
7
passed
days
on
time.
22/8/2025, and almost more than 3 months have already passed. So you have not filed the requisites. You have not taken the phrase step as per the said order or service of notice on OP7 and also the OP9 and you deposit a cost of rupees 10,000 before the High Court Bar Association. Deposit it and then we'll let me. The noting has come that phrase step for service of notice on OP number 7 not taken by the Land Council for the petitioner. Requisites for phrase issuance of notice with correct address to opposite party number 9 not received. You have received the receipt showing the service of copy of the counter affidavit by on both the Land Council for the petitioners also so and so not received.
The Union of India has not served the copy, lordship. Counter copy they have not.
That you have received in the meantime.
No, my lord, I have not received.
Acha.
They have
Union of India has filed the counter affidavit.
They have filed for the railway authorities. Opposite party number 1 to
That
5.
counter affidavit has to be served. I am my name. Petitioners also on you.
My lord.
You have been served counter affidavit.
नहीं रेलवे करो मुझे तो दे दीजिए रेलवे अथॉरिटीज they have served my lord.
Counter affidavit which has been receipt showing counter affidavit on both learned counsel for the petitioner, so also on the learned counsel for the opposite party number 6 not received. The petitioner has received the copy, but you are for the opposite party number 6. You have not received that. So,
And I will start. I am appearing between 1 and 2. My name may be recorded, man.
You saw the counter affidavit copy on the learned counsel for the opposite party number 6.
My lord, my lord.
So far as the counter affidavit filed by the opposite parties number 1 to 5 is concerned, the learned counsel for the petitioner states that he has received the copy of the counter affidavit, but learned counsel for the opposite party number 6 submits that he has not received such copy. Let the counter affidavit be served on the learned counsel for the opposite party number 6 within a week. Stop. Let the land counsel for the petitioner deposit a sum of rupees 10,000 on the High Court Welfare Fund, High Court Bar Association Welfare Fund within 7 days and produce a receipt that to is this matter. We come on 17th of December 2025. Yes, next.
And I may be pardoned, my name may be recorded because brief is interested to me. Opposite party number 1 to 5. Manoj Kumar Pati, Senior Panel Counsel. I will file the
Manoj Kumar Pati, Land Counsel. You are the Senior Panel Counsel, na?
Senior Panel Counsel.
Senior Panel Counsel appears for opposite parties number 1 to 5.
1 to 5, my lord.
Okay. Yes, next.
And my senior was saying he has not received the railway counter probably. Railway counter ta see भी पाई नाहांती
आपण पाई नाहांती रेलवे काउंटर
petitioner
अब कहले हम मारले
तांको काउंटर
has not received question तर both the counter service on the land counsel for the petitioner, so also the land counsel for the opposite party number 6. Hello. Next.
Item 14.
My interim order may continue.
Interim order date shall continue till next date for them. Next date for number 17 तारीख ना. Yes.
Substitution application and served copy on the respondent, and that is allowed me. I was told by the respondent number, the lawyer appearing to the bank, that the co-borrower has expired in the meanwhile, and I have prayed to bring on record the
respondent number 4.
Yes, 4A, that is the son.
So where is your applications? I
19204.
Yes. So any objection? I have told them that 19204 of 2025. There is an application filed by the petitioner for substitution of the legal heir of the opposite party number 4 as per this schedule. A copy of the interim application has been served on the land counsel for the bank who has no objection to such prayer.
I am for the auction for the loan matter.
Oh, अच्छा अच्छा बैंक में
बैंक में से କହିଥିଲା ଜଜାତି ନାହିଁ ଆଜି କହିଥିଲା
अच्छा नॉन अप्यूज को दूं
ନା ନା ସେ କହିଥିଲା ମତେ objection ନାହିଁ ବୋଲି
land counsel for the opposite party number 4 na
ଆଜ୍ଞା
submit that there is no objection. Stop. Accordingly the prayer made in this one also is allowed. The
I am for the three now. 4 will be substituted.
Jai Singh, Ansuman, so and so shall be substituted as 4A. Hello? You have to file that consolidated cost item.
I will file within 2 days.
By Monday?
Monday.
Consolidated cost item incorporating the name of the substituted OP number 4A be filed within by Monday, serving a copy and the land counsel for the opposite bank, also land counsel for the opposite party number 3.
4 ପାଇଁ appear କରିବି ଦେଲେ
Yes, next.
Item 15.
It is a matter where the borrower has paid the entire amount to the bank, and if it is sent to the mediation, that it can be settled.
No,
ତାଙ୍କ
no,
ପଇସା
the only
interest
law-
ସେ ଦବା ପାଇଁ ଦେଇ ଦେଇଛି already bank deposit କରିଦେଇଛି.
But the Cellular LLP stands in Cellular LLP stands there, my lords. It will
No,
be the
no,
problem.
if
I
it-
am
no,
entitled
it is
vessel
not-
certificate has been issued in my favor. After that, deposit of entire amount will not result.
No, it has been deposited since long.
No,
Bank
no,
has-
my lord. After Cellular LLP, my seller certificate that has been deposited. That is the fact.
The matter has gone to the DRT and then DRAT and then.
Yes.
No, no,
No.
DRT go.
DRT
DRT already, it is 9. DRT ଯାଇନାହାନ୍ତି ଆଜ୍ଞା, direct file କରିଛନ୍ତି rate.
DRT ଯାଇଥିଲା ଆଜ୍ଞା, DRT dismiss.
Next.
Much.
Item 15.
Lordship may grant one passover to my senior company.
Passover you are asking for whom?
Mr. Minal Kanungo.
The other side is there.
I'm present, ma'am.
Next.
Item 16.
Lordship, at this matter, this is the writ petition challenging the commissioner's order.
Read appeal, Mr.
Yes, written. Commissioner's order, the consultation commissioner order was challenged in the writ
petition.
in the writ petition, and that was writ petition was allowed, and that order was set aside, and direction was given for recording the land in the name of the.
Let us see that order.
So, Your Lordship, I had submitted the note of submission and citation, everything. And in course of argument, my learned friend raised the question of maintainability and another aspect that matter had gone to the Supreme Court, all these things. But Supreme Court matter, that is no relevance in the matter. There is no relevance in the matter. He has given a bunch of papers. We have found that nothing, no impact on the matter. So far, the maintainability point is there. My learned senior,
Your Lordship has already held in the full bench that this writ appeal is not maintainable as against cases arising out of the special act. That has been held. But that was a case where the statutory appeal was provided for in the High Court, because that was under the Orissa Education Act. Your Lordship will kindly see the page.
That decision 2008 to Wheeler full bench decision 725.
Yes.
Mohammed Saud were looking.
27A.
Recent judgment is that is my Lord Justice Mishra was party to that
full bench.
We said that if the petition is arising out of 227 proceeding.
Yes.
The
but Your Lordship took
writ
note,
appeal is not maintained.
not maintained. But Your Lordship took note of that judgment, earlier judgment, wherein
the settled Supreme Court judgments are also there.
that is there. Only
If
thing is that
227 proceeding, no writ appeal. If it is 226 proceeding, writ appeal. It's
but
simple.
if it is a mix of 227 and 226.
No, it's not mixed. Either it is 227 or 226.
So 2015.
It is a case of 227.
But here, their Lordship consider that in the Orissa Education Act, there is 24A is the appeal is there, but there is no appeal, and after that the appeal is before this honorable court. No second appeal is there. No second appeal is there. In that context, that matter has been decided. But the only thing is 2015 Supreme Court has not been taken into consideration. Whatever Your Lordship think proper can go through it, and what Your Lordship appreciate accordingly. If Your Lordship decide against us, we are out of the court.
We are only suggesting you to go to a wiser court.
Right. So, in this regard, my Lordship
said this
as a prior audience for Your Lordship, he said me that Education Act.
Education Act.
Education Act.
That was a case arising out of
Let us
the
see that case.
Orissa Education Act, my lord, that full bench decision.
Have you got that copy of that order, that the judgment 2008 volume 2 LR full bench 725?
2008 সেটা তারপরে তারপরে এবে ହେଇଛି বোধ হয়।
Now it go first this order.
This judgment, my lord, Justice Mishra, this judgment.
2008 ପରେ ତ ବହୁତ
It is the latest.
latest is 2003.
ମୁଁ ମାର୍କ କରିଥିଲି ଆଉ
They're taking note of that.
Lordship kindly come on paragraph 10.
12, no?
Paragraph 10. No, just the Lordship taken note of that.
No,
background of the guest house.
Background. Paragraph 13, your lordship will see, your lordship has taken note of the relevant provisions under the Orissa Education Act, 24A, 24B, 24C. 24C provides any person aggrieved by an order or decision of judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order or decision of the judgment. In that case, the appeal was provided for the High Court, and from that, the appeal will lie or not lie, that has been decided. Now,
Para 22. Para 22, Lordship taken note of that judgment of Mohammed Sahib.
Here it is stated that after introduction of section 100A of the CPC by 2002 Amendment Act, no later patents appeal is maintainable against the judgment, order, decree passed by a learned single judge of a High Court. And a writ appeal shall lie against the judgment and order passed by the learned single judge in a writ petition filed under Article 226 of the Constitution. In a writ application filed under Article 226 and 227 of the Constitution, if any order, oblique judgment, oblique decree is passed in exercise of the jurisdiction under Article 226, a writ appeal shall lie, whereas no writ appeal will lie against so and so by a single judgment exercising the power of superintendents under Article 226. So this is very clear. So how do you say that?
That was a case, the latest full bench decided that it also applies to the special cases arising out of the Special Act. This is a case arising out of consolidation of revision, prevention of fragmentation and land acquisition. Therefore, it is under a Special Act. But in that case, it was also under the Education Act, it was a Special Act. In that case, there was an appeal provision under section 24C to the High Court. Any person aggrieved by an order or decision or judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order or decision or judgment. Here,
no, that provision is not here considered by the full bench. That particular provision which you are reflecting.
It has been considered paragraph 13.
Paragraph 13?
Yes, sir.
Paragraph 12.
12.
এই মোহাম্মদ সাহর ডিসিশন নেই
ନା 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 ମହମ୍ମଦ ଶାହ ତ ତାର ବହୁତ ଆଗରୁ ଏ ମୁଁ ଓଡ଼ିଶା ହାଇକୋର୍ଟର ଫୁଲ୍ ବେଞ୍ଚ ଡିସିସନଟା କହୁଛି Mohammed Shah's decision is that no appeal lies against an order under 227. Appeal lies against the order of the under 226. I am not talking whether it is applicable to the special cases arising out of a special right and what is the nature of the order has been decided by the latest full bench of this honorable court, wherein your lordships have been pleased to hold that this principle is also applicable so far as cases arising out of the special enactment are concerned.
But even though the writ petition, it has been mentioned, this is an application under Article 226 and 227 of the Constitution.
Yes.
But since the order which has been challenged here is the order dated 26/3/2016 passed by the Commissioner of Consolidation in revision case number so and so.
That is
obviously
not a regular revision. That is not a regular revision out of the order of the consolidation of officer or deputy director consultation.
But the
That is a sole.
We are looking at the prayer in the writ petition. In this case, the prayer in the writ petition is challenging the order of the commissioner consultation.
Under
section, the writ petition has been filed, even though you have mentioned it's 226 in the cause title itself, but it is actually an application under Article 27 of the Constitution in view of the nature of prayer in that writ. So once it is 227, where the question of in view of that decision, where the question of entertaining.
I will only say that after Mahmoud, that South case, my lord, has come 2015 of the Honorable Apex Court.
No, we are not. Mr. Mahanti, suppose a wrong provision has been mentioned. The court has to see that what is the correct provision which is applicable. So what we say, let be an answer from you. That when the order has been challenged of a consolidation commissioner, obviously, even if it is mentioned under Article 226 and 227, whether the writ petition is not an application under 227.
That is not in the superintendence of the matter. It is on
because
the
you see the consolidated commissioner who has passed the order, he is a quasi-judicial authority.
Yes.
He exercising quasi-judicial authority.
Right.
And therefore he passed an order.
Yes.
Then it only 227 lies. 226 doesn't lie.
How can it 26 will lie?
Against an order of a quasi-judicial authority. Simple as that.
Prayer has been made in
here and there.
writ petition. Prayer has been made.
Whatever prayer, is it not quasi-judicial order?
Property shall not be directed to be recorded in it.
Whatever, we are not.
So that is a mandate. That is a mandate was sought.
No, we are not on the nature of the order. An order passed by a quasi-judicial authority exercising a statutory power.
Then the High Court
against that only 227 lies.
Let's go to High Court.
That your lordship held.
The other prayer, then Mr. Mahanti, the other prayer which that is the.
Your lordship will kindly appreciate the question.
That is considered.
When he came directly under consultation division, the case was filed. Then that was negative. Then it was at his instance to record his name. He came before the Honorable Court. We never came. I may consider he was the writ petitioner. So, in the writ petition, it was allowed. Writ petition was allowed in his favor, and it was directed by this Honorable Court to record his name.
That is on merit.
That is what will be the nature of that direction, my lord? You do it a direction.
No, kindly see the prayer. Prayer says, was the order dated 29/3/2016 passed by the Commissioner of Consolidation.
He has made that prayer. What can he do? I don't have any control. I was the opposite party in that case.
No, that's right. Readable is not maintainable. Somewhere else you have to tell all this.
No. The direction for the first time, consultation revision order was in favor of mine. Then he came here. And that was set aside with a direction that no, his name should be recorded. So, whereas the question of mine coming again in writ appeal,
Mr. Mahathir,
I am coming for the first time in the writ
Mr.
appeal.
Mahathir just want another that suppose this do you mean to say that the maintainability aspect cannot be raised at the final stage of hearing? Is it your
No.
That can be. But only thing I will draw
I
the
think
2015 Supreme Court, which has not been taken into
Maybe
consideration.
whatever you are saying, you can maintain an independent
It
treatment.
has not been taken into consideration.
what
Maintain a independent
probably I was not clear. I
Because
was telling
it was deleted
that
where no second appeal was provided. So that is why here also no second appeal is provided.
We propose
Therefore,
one thing on this written maintainability aspect. You file your whatever submission and let him file. The other side also file. We'll decide this at the first juncture. If we held to be maintained,
Yes.
then we'll proceed. Otherwise,
I have already filed the written
on this maintainability, let us see that.
this is a
point
copy this.
Maintainability.
What my contention is something different. My contention is that under the statute there is no second appeal. In the full bench decided by the honorable Judges Miller, there was an appeal provision to the High Court. Therefore, it will be treated as a second appeal. But in this case, the revision was
petitioner.
Revision, consultation.
You have filed.
Yes, I.
Very that. Please see it. A written note of argument has been filed by the petitioner.
Petitioner, we have filed the exhausted note, but so far the maintainability point, we have not tossed that.
No, but he has filed something.
Notes of argument on behalf of respondent number 5.
Where is that?
One thing I want to.
Acha, all right.
Mr.
Let us be clear. He has actually filed a note of argument on behalf of respondent number 5, where he has raised about this maintainability aspect. Where you have stated, Mr. Let us see that.
That copy may be given to us. Is not. This is something else.
Copy I have given.
No, this is something else you have given.
No.
I will give it.
Yes, he has dealt with all these things in detail.
And one thing I want to draw your lordship's attention that in your lordship's judgment reported in 2019 supplemented to OLR, page 818, there at para 7 your lordship have held like this. The limitation, the power of the court imposed by section 100 and 101 of CPC cannot be made applicable to an appellate court hearing a letter patent appeal for the simple reason that a single judge of the High Court is not a court subordinate to the High Court. Your lordship in division bench has also held like that. And also in the Lockmark case, my Lord Justice Mishra was a party. There also your lordship was categorically laid down the points.
You do one thing, please survey.
Yes,
can we get your note on this mentality? Because
yes.
we can take up this matter on Wednesday, so that please file the note so that it can be Wednesday means this is the calendar. Mr. Mahathir,
this side.
Not on Wednesday. My lord, not on Wednesday. Any other? No, I thought it is.
11 হবে এই
11 সে গুরুবার পড়ছি আর মঙ্গলবার
হ্যাঁ গুরুবারটা সরি 9th
হ্যাঁ
9th রে भी বেঞ্চ নাই ফের যায় 12th
আচ্ছা লিখুন তো the Mr. Mahapatra Land Council appearing for the party number कहाँ पर है?
Respondent number 5.
अच्छा respondent number 5 has filed a note of argument in which he has raised the point of maintainability of this writ appeal, and he has relied on some decision of this court
as well as Supreme Court decision.
Order against
as well as the decision of the Honorable Supreme Court. Mr. Mahanti, a senior advocate appearing for the petitioner, submits that he has not received the copy of such argument note. Stop. Let a copy of the argument note be supplied to the Land and Council for the petitioner by you do it by tomorrow or day after tomorrow?
Day after tomorrow.
By day after tomorrow. On consensus of both the parties, ଆପଣ କହୁଛନ୍ତି 8 ତାରିଖ ଆସିବ ନା କେବେ କହୁଛନ୍ତି?
ନାଇଁ ମୁଁ 8 ତାରିଖ କହୁନି
ନାଇଁ ସେଇ କହୁଥିଲେ 11th ଯେ ମୁଁ କହିଥିଲି ନା 11th PIL ବେଞ୍ଚ ଟା
ନା 11th ରେ ସେଟା ଗୁରୁବାର ସେ ଗୋଟେ ସେପାରେଟ ବେଞ୍ଚ ହଉଛି ତ ମଙ୍ଗଳବାର ଗୁରୁବାର ତା ଛଡା PIL ବେଞ୍ଚ ବି ଅଛି ସବୁ ତେଣୁ ଅନ୍ୟ ଦିନ କୁହନ୍ତୁ ସୋମବାର ମଙ୍ଗଳବାର ଆଉ ଶୁକ୍ରବାର
ମଙ୍ଗଳବାର
ଡେଡିକେଟେଡ ବେଞ୍ଚ ରହୁଛି 2 ଦିନ ସେ କ୍ରିମିନାଲ ଅପିଲ ଶୁଣା ହଉଛି ତେଣୁ
16 ତାରିଖ ରହୁଛି
16 ତାରିଖ 15 ତାରିଖ
15 ଡିସେମ୍ବର 2020 ଟିକେ ଆଗରୁ ଆପଣଙ୍କର ଇଏଟା ଦେଇଦେବେ ଆପଣଙ୍କର written note of argument
citation
to be served in advance to the Land Council for the respondent number 5 so also be filed 15/12/2020. Yes.
Thank you.
You be some sergeant and the question. How will you put them to some or Xerox for you that is all. No? Okay.
Item 16.
16 gala par.
Item 17.
May please, Your Lordship. My Lord, kindly the last to the last order.
You're feeling for that. They go.
Prefer panel
Advocate Simon Kohil. You are supposed to tell us High Court koro gote bartan panel advocate he jeichi jetiko Odisha High Court who represent Saman karibe. So not you. So that is why we asked you to obtain instruction from the registry that whether any counsel has been engaged to represent the Odisha High Court or the district judge, whatever it is.
Just ask.
Just ask ଏଥିପାଇଁ କଣ ଗୋଟେ ଆପଣ ଟାଇମ୍ ନଉଛନ୍ତି ଗତ ଥର ଅର୍ଡର ହେଇଥିଲା ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସ ଅର୍ଡର ହେଇଥିଲା ଏଟା.
Why are you surprised?
My Lord, the High Court separate panel is there.
Yes, just see the order and ask the register. You're getting surprised? Maybe something big has happened.
Since in the meantime a panel has been formed to represent the registry of this court, Land and Council for the state seeks some time to obtain instruction as to whether any counsel from the panel is to be engaged for the opposite party number 1 or not. Order is very clear. Or you are surprised that then we are nua kon pass kulu aji 26/11 order to bujiba kata registry ko
Last time Mr. Naik appeared. Sir, Naik.
ଆପଣଙ୍କର ଆଜି ଇଏ ଜଣେ କାଲି ସିଏ ଜଣେ appear କରିବ that we are not least concerned, but you obtain that instruction. We are keeping it to Monday. The Land Council for the state submits that as per the order dated 26/11/2025. He is yet to obtain the instruction, and the matter may be taken up next week. List this matter on 8th of December 2025. This rest of the matter will come on Monday.
Item 15, which has been passed over.
Monday it will come.
1 week after.
The council.
I've taken the consent of Mr. Bhatt.
28 मिला.
Who's appearing for the opposite party.
15.
Mr. Patnaik is here.
Mr. Milan Kanungo and senior advocate is present, and he seeks for an adjournment on with this matter on 15th of December 2020.
Mr. Patnaik.
Mr. Patnaik, Mr. Kanungo wants it on 15. Any objection? Mr. So Mr. Patnaik is present for OSFC, na?
My lord.
OSFC. So 15/12/2025.
Item 28 मिला. That the electricity supply matter. My electricity supply has been installed मिला. Your lordship.
Interim order में continue.
Interim order is there to continue.
Sir, मैं paid for base admission.
Put a failure. Item
number 28.
You make a mention on that day. On so Monday, you make a mention in the first hour. Yes. Let it come because the final disposal heading of chief, you make a mention. We may after this phrase admission, we can also take up your matter. Fine.
Submission with regard to item 26.
Yes.
This is a matter where the sale certificate has been issued. I am for the auction purchaser. Your Lordship, after seeing the order sheet of the DRT, had stayed for the proceedings because despite an application to vacate the interim order, it was not being done. It was being pushed from day to day, and since 2023, having paid the entire sale consideration and having obtained the sale certificate.
Which item it is?
Item 26.
Item 26.
They have taken a stay by making a submission that the property is a residential house. I have given
26. It is Manoj Kumar Mishra.
My lordship, my behalf of kindly pass.
That is not your matter, Mr. You may be 27, Mr. Mukherjee. It is, I think, 27.
No, Gudla Satish.
That is 27, not 26.
Sorry about it. 27.
We'll take up this matter on Monday.
I was only saying that let be taken up immediately after the fresh admission matter. So
just make a mention of that.
I'll do. Okay.
Hello.
want to make a mention of this. Item 53 in today's list, my lords. We have filed an IE for interim bail with regard to petitioner's wife's illness, my lords. The report has yet not come, my lords. I pray telephonic instructions may be obtained from the IIC of Aska PS, my lords.
No, yes, they are.
Even the wife is in need of urgent.
I'm sending the court visual letter also. Can take that.
Yes, call the man.
Supplementary release second half. Press admission item 1.
My lord, items 37. I have a file this case for interim bail, my lord. The father of the petitioner, my lord, hospitalized at government hospital, Colombo, and doctor referred to higher medical, SV medical or Vimsar medical.
Wait. Item number 1. May I please also. Present applicant convicted of a imprisonment for life, law section 302 of IPC. All right. Call for the trial court of applications for bail and sterilization and consider yes.
Item 2.
Yes, 302 case na kaun eta? Mr. Nayak,
Merit.
302. So it is in time. So admit you least to achieve further engage further. Next.
Item 3.
So judgment was something. Sentence to the 302. अच्छा डिले डाउनलोड कर देवे से फॉर्मेट कॉपी एडमिट करिକି नहीं सीरियली एंगेज करिवे हां अतम पछियार देवे खाली नेक्स्ट
Item 4.
302 257 अच्छा 257 डिले डाउनलोड हां एंड एडमिट कर देगी नेक्स्ट
Item 5.
Release on loan, admit, investigate.
Item 6.
May I please, your lordship. Appellant is convicted under sections 364 and 302 IPC, and 15 witnesses have been examined, relying on the position of PW 3, 4, and 5, corroborating with PW 8's evidence. The trial court has convicted the appellant. Your lordship has granted bail on 5/5/2005, and the appellant appear in receipt on 22/10/2025. But no one is there to take him in bail. So till date he is custody.
All right, then let him remain. We have to hear the matter. You are ready.
Your lordship. Your lordship.
Have you received the paper book?
I have collected one.
Yes. You have got the paper book. We will fix it for hearing now. No question.
See, please.
Bail we have granted. If he has not gone, what can be done? A double mark. No, it's all right. We will just add it to the hearing list. Let on. In view of our previous order dated 29/10/2025, the matter be added to the hearing list. Hearing list requires the order second. Order is very specific. On 29/10/2025, we have passed the order that matter be added to the hearing list since paper books are being prepared and why it has come for orders. We added to the hearing list. Yes, next.
Item 7.
In item 7, I have filed an IA for bail matter 4/11/2025. That has not been brought to record.
Can you tell the number of that IA?
411 of 2025.
411 of
2025.
Have you received a copy of that?
No.
When you filed that IA?
When
When you filed?
Yesterday.
Yesterday. Acha, Mr. Rajguru Amalkas submits that an interim application for bail has been filed yesterday, which has been registered as IA number 411 of 2025. Copy of the interim application for bail is handed over to the Land Council for the state in court today. How many years he is in custody?
12 years, 6 months, more than 12.
Sure. Let the Land Council for the state produce the custody certificate, criminal antecedent, and also the conduct of the petitioner in jail. तीनटा जिनसे मगे हुए
23/5/2013.
ठीक है जी. Matter will be listed on 15th of December 2025. Okay. Acha, the interim application be placed on record like that. On 15th December 2025 with IN number 411 of 2025. Yes. Okay.
For orders, item 8.
Last exam that of the instruction whether they are dead or not. From that respect,
you produced a letter which is dated 3/12/2025 of the Sarpanch Hunta Bandha Gram Panchayat that the appellant died since last 4 years while he was in Noyagarh jail. And we asked you that you are to obtain the confirm letter from the superintendent of Noyagarh's jail regarding the death of, because it must have been reflected there.
yes,
So you have got the
that first is one postmortem report, and that another magistrate would be.
As per the order dated 3/12/2025, the Land Council for the state has produced the written instruction from Superintendent Subjail Noyagarh, which shows that the appellant Sudarshan Rao died on 23/12/2021, and he has also produced the postmortem report of the appellant. The documents are taken on record. The since no near relatives for the appeal abet further. अच्छा ये सोल appellant तो श्योर हाँ ठीक है ओके नेक्स्ट
Item 9.
In this case, my lord, the petitioner is convicted for 302. Evidence copy kindly be directed to
take it in
supply.
your pen drive with
Right.
us. Sasmita Nandal and counsel appearing for the appellant submits that she may be supplied with the deposition, soft copy of the deposition of the witnesses examining the trial court. Let the registry supply the same to the Land Council in her pen drive. କେବେ ରଖିବା କୁହନ୍ତୁ ଏ ତ ଆଜି ଦେଇଦେବେ ଆପଣ କେବେ ରଖିବା କୁହନ୍ତୁ ଆପଣ କହିବେ ନା
छुट्टी पर
ଛୁଟି କରୁ
And this may be separate to state also.
ଆଚ୍ଛା so also to the state ଛୁଟି पर ରଖିଦେବେ after when the week commencing from MTA type of it, not after winter vacation, ସେମିତି ଦେବେ
Item 10.
फाइन में भी स्टेट
আচ্ছা এইটা আইএ যেটা আছে ওই স্টে রিয়েলাইজেশন অফ ফাইন এটা অ্যালাউ করবে তাই না ফাইন স্টেট
May I please, your lordship? As for last order, my lord calls for that appellant's age and
ସେଭେଣ୍ଟି ଥ୍ରୀ ଇୟର୍ସ ଲେଖା ହେଇଛି
my lord.
ସେଥିପାଇଁ କହିଲା ତାକୁ ଇନଷ୍ଟ୍ରକ୍ସନ ନବାକୁ ପ୍ଲସ୍ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ସଞ୍ଚ ଦେଖି କଣ ଆସିଲା 4 ବର୍ଷ 9 ମାସ 18 ଦିନ beautification behavior is good is 73 years old so for the path offense
302, my lord, that case is based on circumstantial evidence that there are 22 numbers of prosecution witnesses. Out of 22, 6 to 15 they are turned hostile. They are not supported the prosecution case. And PW5 is the informant in this case.
Oh, what are the circumstantial evidence?
Circumstances, my lord, that when the appellant is working and
no, last seen extrajudicial confession like this, what are the materials?
Materials means it is not specified like
the circumstance would have could lekha judgment re.
No, my lord, this circumstances is not defined properly.
Last seen achieve. Are you prepared or not?
Yes, my lord, it is last scene only. There.
Who has stated about last scene? Whether extrajudicial confession is there?
Not extrajudicial confession was there. In hearings in judgment first para.
We want you to tell us that if it is a case based on circumstantial evidence, what are the circumstances on which reliance has been placed by the London trial court to convict the appellant? And who are the witnesses on that circumstance? If you are not ready,
in first para in judgment first para it is mentioned that hearing shouting in judgment first.
On judgment of first para.
The accused holding a
that is the prosecution case has been,
my lord.
What are the circumstances against you for which you have been found guilty? You have not gone through. Go through it.
Circumstances 1, 2, 3. You have to find out.
That circumstances is not.
What are the circumstances? One is last in theory. You said who is the witness to last in theory?
Prepare in that way.
My lord.
Whether 27 recoveries are there or not.
These are
all these things one after one another.
The London Council for the petitioner seeks some time to prepare, put up this matter on 15th of December 2025.
Okay.
Yes.
Item 11.
May I please, lordship?
You see, you are getting a chance to argue. You have been appointed by the legal aid service.
No, my lord.
It is your brief.
My lord. Well, I prepared. In judgment itself.
Yes, next.
You have not structured it.
My lord.
What is the you have to structure your argument.
My lord.
Place it in a note form.
May I please, lordship? Assistant CA controversy called for my.
Is it there, Mr.
Custody is more than 8 years.
E174 মানে Hon'Ble যেতে হবে।
Even
8 years 6 months.
8 years 6 months.
Contact କଣ ଅଛି? ଠିକଠାକ ଅଛି?
Nothing adverse to occur.
କୋଉଠି ଲେଖା ଅଛି? ଆରେ ତୁ ଗୋଟେ କଣ ଦଉଛୁ? Yeah.
I think it was.
କଣ କୁହନ୍ତୁ କେସ୍ ବିଷୟରେ କୁହନ୍ତୁ?
The case of double murder matter. And the eyewitnesses are the informant herself and the 3 and 5.
So,
the PM doctor is 15 and 16.
eyewitnesses have supported the prosecution case.
Yes, sir, they are the related
Then let it
witnesses.
be February government. For the custody certificate and the conduct certificate, criminal antecedent report. Is in the February.
The stay, there's a fine.
Sterilization fine तो नहीं order
I filed matter 4 foot.
The order might have been passed.
I actually filed today file matter.
वो आज ही file कर लो.
Yeah, I number is 414.
आसु report. Yes.
For orders, criminal appeals, item 12.
May I please the lordship, madam?
Just a minute.
In this. In this case also that was called for CA conduct and I'm in custody since more than 15 years.
Custody में. There are two appellants.
Yes, I am for Asar Kumar.
Appellant number?
He is the husband.
Husband.
Yes.
The
The appellant
498
4B 302.
What about the other appellant?
The last time at the another counsel was appearing, but I have the instruction. My father has died, man.
No. That's
in the year
he
2016.
was released on bail.
Yes, by the Supreme Court. And he's dead now.
Dead now, kahin tar ye kahin? Any document?
None.
Then
I am for only one man.
ବୁଝିଲି ଯେ one କଣ ଜାଣିନ ଆପଣ ଏଟା update କରିବ ନା so far as appellant number.
Verify. Appellant number 2 stated to have died.
On that respect,
Verify it. That will be a bit the appeal level.
Ashok.
That appellant instructed me, informed me, madam. Therefore, my matter he has in religious follow matter. From 21/12/2015 to 16.
Because he died.
କେବେ ଯାଇଥିଲେ prolong period?
21/12/2015 to 3/1/2016. For
3/1/2016.
For only 12-13 days.
ते तू इज लिखा है
मला त्यातलं 7/2/14 ରୁ 20/2/14 14/2/15 ରୁ 17/2/15
नहीं prolong तो जीरो लिखा है ना prolong जमा जाई नांती interim bail जाई नांती prolong जाई नांती parole ले खाली जाई चंती 1 year 10 months really total लिखा है maybe that all right you obtain that instruction the अच्छा ये आदर कौन अच्छी case कौन
Circumstantial evidence matter.
no the wife died by what way?
That is a homicide matter.
Achha.
And the asphyxia due to strangulation, the report is there. And these appellants were not in the house. Yes, based on the dying declaration, when she went to her house some 2 to 3 months back, that is treated as joint relation. And one extrajudicial confession before PW2 that has not been believed by Honorable Trial Court Ma'am. And presumption under section 113B. This is the matter.
What you say the 16 वर्ष ହେଇଗଲାଣି the land council for the British state has produced the custody certificate which shows that the custody period of the petitioner is more than 16 years. This is IN number 1925 of 2018 application for bail of appellant number 1. Appellant number 1 होची अशोक कुमार.
Ashok Kumar.
He has also produced the report from the IIC Sadar Police Station, Fulbani, to show that there is no criminal antecedent against the petitioner. His conduct certificate has been produced, which is mentioned to be satisfactory. The documents produced by the Land Council for the state taken on record. Considering the submission made by the Land Council for the respective parties and the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail. Stop. तापरे गोटे ऊपर लेखि दियंतु क्रिमिनल अपील ले तापरे आईएटा ता परे लेखियो at the outset Mr. Mishra, Land Council for the appellant, submitted that the appellant number 2 Sahadev Kahan is the father of appellant number 1 who has been directed to be released on bail by order dated 25/2/2011 and he is now dead. The appellant number 2 is now dead. As respond to him from jail by appellant number 1, Land Council for the state may verify this aspect to the concerned IIC and produce the report. आपण এই রিপোর্টটা প্রডিউস করুন आप तो बेल छाड़ देलु এটা কেবে রখিল হবো 15th রে পাইবে on the release this matter on 15 December 2025 for producing the report है on the concern बाकी तापरे आई एटा लेकिन बेल देबे है ना. Yes, next
Obligation, ma'am.
Item 13.
Prisoner petition is there, my lord. Appellant number 2 in CRL number, my lord, 386/14.
Prisoner's petition, appellant number 2 regarding engagement of RB Mishra. How many appellants are there totally?
Total, my lord, there is 3 appeal, my lord.
3 appellants, but ଗୋଟେ appellant separate appeal file କରିଛି 720.
My lord, so 20ଟା 386 ଏ 14 ରେ appellant number 3 ଥିଲା. ସେଟାକୁ order ରେ ୟୁଏ ଦେଇକିରି ଏ separate appeal ରେ 720 ଶୋ ହେଲା.
ଠିକ ଅଛି ବର୍ତ୍ତମାନ ତେଣୁ ଏ appeal ରେ ରହିଲେ 2 ଜଣ.
My lord.
ବୁଦ୍ଧନାଥ ଆଉ ମୁନ୍ନା ମହାନ୍ତି.
My lord.
So this application, the prisoner's petition has been received so far as appellant number 2 is concerned.
My lord.
So where is that? Prisoner's petition now. The prisoner's petition of appellant number 2, Munna Mahanti, in which a prayer has been made for engagement of Mr. Rajiv Bihari Mishra as his counsel in place of Mr. Tara Prasad Mahapatra. Mr. Mishra, you have filed the wakalatnama? Mr. Mishra has already filed the wakalatnama. The name of Mr. Mishra is also appearing in the cause list stop. And Mr. Mahapatra pai ki achandi? Tara Prasad Mahapatra pai? He is appearing for appellant number 1. Acha, like non appears for appellant number 1. What do you say?
IA number 3045, I am custody minor 18 years.
So what are the earlier application is pending? This case number 1150 of 2014. Stay relation of financial. You would have file and stay relation. out of 306.
Minor fees.
आपन फाइल कर देने बस. अच्छा. But the problem is that this sterilization of fine has been filed only for appellant number 2. Whereas the earlier application, the stay application fine that is filed for both, and that no order has been passed. So now that will be confined only to appellant number 1, the earlier one that is pending.
No, they will withdraw this and that allow that.
Good.
इसको withdraw तको लग पर तो बिरनो बैठन तको allow करके तो withdraw
You can do appeal for the fine.
exemption.
All right. IN number 3045 of 2025. This is an 3046 of 25 is an application for stay of realization of fine. Since another application is pending for the self-same purpose with self-same prayer, that is miss case number 1150 of 2014. This application is not pressed. The land council for the petitioner does not want to press this application. तापर मिस केस नंबर 1150 of 2014 में stay of realization of fine grant कर दी. Now we come to the bail.
I am already 18 years of custody in similar footing. My lord CRL 720/16 order dated 23/7/24 रे similar footing रे कड़ा छोटे आज release on bail man.
18 years.
18 years man.
Where is the custody certificate?
It's not with me.
Who has been granted bail, you said?
My lord, कड़ा छोटा है in CRL number 720/16 order dated 23/7/24.
देखिले कस्टडी सर्टिफिकेट अछि कि कस्टडी सर्टिफिकेट लेखନ୍ତୁ आईए नंबर P045 of 2025 बाहर करो सर. This is an application for bail filed by appellant number 2. ना लिखी देवे. Mr. Mishra and counsel appearing for the petitioner submits that the petitioner is in judicial custody for
more than 18 years.
Stop. Land counsel for the state seek some time to produce the custody certificate. Is this matter? आरो शुक्रवार actually आनी पड़ेगी. पूरी जेल में आते. Leave this matter on 12th of December 2025. Yes. Okay, please.
Item 14.
May I please?
Koda. Council के नाम. We have only.
You are appearing for that. Why don't you tell?
Koda.
To sub item 236 of 2014.
No, but there is no interim application here. Sadhir bail madam apanଙ୍କର client को.
Yes, your lordship. The bail was granted earlier in 2014, your lordship. 15/14.
ठीक ଅଛି ताले खाली you are to supposed to obtain instruction regarding death of appellant number 3 that you want for the time. All right. It are लिखी दियो.
Certificate.
CRL. Yes, ma'am.
Death certificate is available with respect to the death of Kiran Koirasina Das. That is appellant number 3. Same is not legible, your lordship.
No, where it is available. No, I think you see, there is a letter number 840 at flag A. It indicates in inviting the reference subject cited above, I am to honor that Titas Das alias Kiran Krishna Das, son of so and so, died natural death on 22/2019. See what about the appellant number 3?
ସେଟା ଆସିନି ଡେ ସାର୍ଟିଫିକେଟ ମାନେ
ଆରେ ଆପଣଙ୍କର OIC ଦେଇଛନ୍ତି ଆସିନି କଣ?
ଖାଲି ଯୋଉ ଡକୁମେଣ୍ଟ ଟା ନାହିଁ ମାନେ ରିପୋର୍ଟ ଟା ଦେଇଛି
ଓ ଖାଲି ରିପୋର୍ଟ ଡେ
ଡେ ସାର୍ଟିଫିକେଟ
ଡେ ସାର୍ଟିଫିକେଟ ସେ ଦେଇଛନ୍ତି ପରା ହେଡ କହୁଛନ୍ତି
Dave, it's not that legible, so they
Yeah.
usually handed over a legible document. By September 2009.
ଲେଖା ହେଇଥିବ ଇସ୍ୟୁ ଡେଟ୍ ଅଫ ଡେଥ୍ ଏଇଠି ଗୋଟେ ଲେଖା ହେଇଛି ଏଇଠି ଗୋଟେ ଲେଖା ହେଇଛି 22/9/2000 ହଁ ଅଛି ତ ଠିକ ଅଛି ଆଜ୍ଞା it is there no ଲେଖନ୍ତୁ the report furnished by the OIC Balanga police station dated 13/3/2024 indicates that Titta Das hochi appellant number 3. That
Yes, sir.
appellant number 3.
Yes, sir. Titta Das alias
Yes,
Kiran Krishna.
Kiran Krishna Das is dead. The Land Council for the appellant also produced the death certificate of appellant number 3, which is taken on record. Since no near relatives of Sujan people, it abet karibo so far as appellant number 3 is concerned. It is in criminal appeal number 236/2014. This is the appellant number 3 abates karibo. Next.
Item 15.
I am to BC Malad.
Don't do it. 14, madam. 14 টা রাখি
14.
Item 14.
14
ঠিক আছে
may I please notes item 14
the guide করନ୍ତୁ ମୁଁ ପିଲା ଜାଣିନି ଯେ item 14 କୁହନ୍ତୁ
the prisoner the appellant is I am for the 305 appellant is punished for life imprisonment under
IA number 2363 of 24.
IA number 2363 of 24.
So what order was passed previously?
To obtain instruction by the state for the antecedent and no order is that only antecedents is been called for.
He has filed an interim application for bail. Objection somebody has filed. Objection to the bail application filed and kept on record at flag N. Then additional affidavit so and so.
By the state.
Who has filed this objection?
By the state.
Flag N filed by the state. State objection.
State has filed along with the antecedents.
Have you received a copy of the objection?
No, copy is not subject to us.
You don't require it. So many things have been stated against you in that objection.
So they have filed only. I come to know that the two antecedents for which I am acquitted.
That is not antecedent. So many things have been stated against you. Go through the objection.
It's a very lengthy one.
7-page objection has been filed. Copy ଅଛି କି ଆପଣ
Sorry,
I missed it.
You say, have you filed any response to that?
No, I am not.
Then they have stated like this that you come to paragraph number 13. After telling that what are the materials against you, if the convicted accused is released on bail, may take revenge on this one, so then he may create havoc in so and so.
That
Released on bail, similar type of offences under Patamundi Model Police Station. Then the criminal activities will so because of the fact that you are having that criminal antecedent and this is a case under section 302 IPC, so they have filed the objection. Ordinarily they don't file objection, the state, but they just make oral submission. But here is a case they have filed objection. So something serious.
That objection is not handed over to me. This is the additional affidavit is given to me. Copy of additional affidavit filed on 10th May 20.
Objection to the bail application.
No, copy is not
IU number 2363 of 2024. There is an application for bail. The state has filed objection to the bail application. London Council for the on 28th November 2024. The London Council for the appellant submits that he has not received the copy of the objection. Are you having that copy with you? Huh? Please hand over a copy. Let a copy of the objection be handed over to the London Council for the appellant. It is this matter on 15th of December 2025.
Item 15.
Sahoo.
My lord, I am from DC, my lord. My lord, on the last occasion, your lordship directed the State Council to obtain the custody certificate of the present appellant and the conduct of the present appellant. The appellant is in custody since 18/6/2014.
Let's go. Custody certificate and criminal antecedent. Ticket given. What about the other things, criminal antecedent?
Confirm my.
Conduct paper or? କିଛି ଅଛି କି criminal antecedent ଅଛି? Documented. What is the case against you?
My lord, there was eyewitness to the occurrence. PW14 is the informant and as well as the.
Whether your bail application was rejected earlier on merit?
No, my lord. This is the first bail application. Co-accused has granted bail by order dated 21/1/2021. My lord,
Wrong. appellant number 1 to we are
I
inclined
am appellate for one.
to appellant number 2 acha ethre appellant number 1 ku reject heichi.
My lord, appellant number 2 was granted bail.
Now you are moving bail application for appellant number 1.
My lord. हुआ ले तो संभव मालिक.
Land Council for the State has produced the custody certificate of the reason application for bail for appellant number 1. The custody certificate which indicate that the custody period of the petitioner is more than 12 years and 8 months. And the jail conduct of the petitioner is also satisfactory. Stop. Land Council for the state also on instruction submits that there is no criminal antecedent against the petitioner. Land Council for the petitioner submits that even though while granting bail to appellant number Nogada alias Nagarjun Malik had order dated 21/1/2021, the bail application of the petitioner was rejected, but in view of the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail. Considering the submission in view of the available material on record while not inclining to the petitioner on bail on merit, however, taking into account his period of detention and principle down in the case of Lekki versus Swanswell, 3 months bail granted. Is it fixed up for the future?
Item 16.
Yes, my lord. My lord, here the petitioner is languishing in jail custody near about 13 years, 12 years, 9 months. And my lord also granted interim bail for 3 months on 19/6/2025, and he was also surrendered in time.
ଏଇଟା ଆମେ କହିଥିଲୁ ଆଣିବା ପାଇଁ ଆପଣ ସେ ଯୋଉ IIC ଟୁ ତାର ଯୋଉ ବେଲ ରେ ଗଲା କେମିତି ଆପଣ ନିଆଇଲି ଏ ଯୋଉ ଜେଲ ର ରିପୋର୍ଟ ଅର୍ଡର ଟା କଣ ବୁଝୁନାହାନ୍ତି କି ସେ ଯାଇଥିଲା ଇଣ୍ଟରିମ୍ ବେଲ ରେ ତ ସେ ତ ଗାଁ ରେ ଥିବ ତେଣୁ IIC ରିପୋର୍ଟ ଦବ। କୋଉ ଅର୍ଡର ଯାଇଥିଲେ ଆପଣ?
Sir, 19/6/2025.
କେତେ ବର୍ଷ ରହିଲା ପରେ?
After 12 years. More than 12 years. He was in custody since 29/3/2013.
Are the Land Council for the petition Land Council for the state. This is the IA number 2735 of 25. Grant of bail to the petitioner. Land Council for the petitioner Mr. Panda submits that the petitioner has remained in judicial custody for more than 12 years and he was granted interim bail for a period of 3 months as per the order dated 19/6/2025 in IN number 865 of 2025, and after availing the same he surrendered at right time.
Right time.
When the matter was taken up last time, we asked the Land Council for the state to obtain the report from the IIC of the concerned police station regarding the conduct of the petitioner while on interim bail. Today, the Land Council for the state has produced the report dated 29/11/2025 of IIC Sadar Police Station, Fulbani, Kandamar. This shows that during the interim bail period, nothing adverse was found against the petitioner. The report is taken on record. The conduct of the petitioner inside the jail was also produced, which was found to be good. The same was also taken on record. Considering the submission made by the Land Council for the respective party, period of detention of the petitioner in judicial custody, since the petitioner has not flouted the terms and conditions of the bail order, absence of any chance of early hearing, and keeping in view the ratio laid down in the case of late the bail application is allowed. Yeah.
Item 17.
Prisoner's prison. Yes, my lord. At flag is single appellant. My lord. Engagement of so and so. Wakalatnama file. Appear the prisoner's petition, in which prayer has been made for engagement of Mr. Chittaranjan Sahu as his counsel, in place of the earlier counsel, engaged counsel. The prayer is accepted, so and so is engaged as the counsel for the appellant. Mr. Sahu has already filed Wakalatnama file. Yes, file Kurchanti. The name of the other counsel except Mr. Chittaranjan Sahu and his associates shall not be reflected in the cause list henceforth. Yes,
my lord, the appellant is custody more than 12 years, my lord, 12 years, 6 months.
Anichandi. IN number
paper book is
paper book paper book you have received the paper book?
Yes, my lord.
Look on IN number 2879 of 2025. This is an application for bail. Land Council for the state submits that he may be supplied with a copy of the paper book. Let this same be supplied to him. Matter will be listed on 15th of December 2025. Yes.
Custody certificate.
Custody certificate. अच्छा custody certificate तापरे हमारा CA और jail conduct तीनटा का नहीं है
Item 18.
Custody for more than 14 years. And out of that, I was kind enough to grant him interim bail for about a year. So excluding that, it will be around 13 years.
Interim bail after having a surrender.
All the time he has surrendered in time.
He has become infectious. So your IA is a Shanwa IA.
2584 of 2025.
What about the custody? अच्छी क्या आगू रास्ते लगी?
आगू रास्ते क्या? Let me see in IA number.
If you like,
2110 of 2025, I called for a report.
Neither there is an allegation. वो तात्पुरपुर भी से जाएगा.
Around 5 times my lord has condemned granting bail. All the times he has surrendered.
The auditor ଲେଖା ହେଇନି ଆପଣ କେତେ ବର୍ଷ ଥିଲେ ବୋଲି?
More than 11 years.
40.
More than 11 years. There is the custody certificate available on record. And which indicates that the petitioner is in custody.
Double murder. ଯାଇଛି ଆଉ bail ଯାଇଛି ଲେଖୁନ the IN number so and so is an application for bail. Mr. Chand Land Counsel for the petitioner submitted that the petitioner is in judicial custody more than 11 years. And last time I had order dated 26/20/25 The petitioner was directed to on interim bail for a period of 3 months. And after availing the same, he surrendered at right time.
That 3 months it was extended for 1 month. 3 months पे ଗୋଟେ ମାସ ଦେଇଥିଲେ
which was extended for another month. And after availing the same, he surrendered at right time. And even prior to that, the petition was also
4 times. I have
granted interim bail.
Again.
4 times stop. And on each occasion, he has not flouted the terms and conditions of the interim bail order. He further submits that since there is no chance of early hearing, the bail application may be favorably considered. Considering the submission made by the land council for the respective parties, period of detention of the petitioner in judicial custody since the petitioner has not flouted the terms and conditions of the interim bail or granted earlier by this court and surrender at right time, and taking into account the absence of chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 19.
Two connected appeal matters. In first appeal, appellant is a lady, criminal appeal number 653 of 2017.
Manoma Jena.
And the other matter, a male person is there. 498.
No, who is this Manoma?
Is the mother-in-law.
So how many years she is in custody?
She is in custody.
Custody certificate also there. Kind flag. Monorama Jena, acha, 18 ବର୍ଷ 3 ମାସ এটা হচ্ছে অক্টোবর মাসের more than 8 years. So what is the cause of death?
The burning, dying declaration.
Dying declaration there.
Dying declaration আছে কত নম্বর
two
exhibit কে দেই oral না written?
Written
18 exhibit 18 oh exhibit 8
ଆଜ୍ଞା
ତୁମର ନାମ କଣ ସୁଆଂଶୁ ବିପ୍ଳବ ଦିନ ଆଚ୍ଛା ମୋ ଦେହ କିପରି ପଡ଼ିଲା ଫାଇଲ ଗତ ବୁଧବାର ଦିନ ପ୍ରାୟ ସୁଆଂଶୁରେ ମୋ ଶ୍ୱଶୁର
और exhibit 11 also better ticket re
exhibit 11 भी अच्छी ना
आगे
exhibit 11 टा देखो
better ticket टा the nurse who was there she examined as DW. She has said nothing, no something has happened. Was allegedly present at this time of recording of false things. She has said no to false things. Some discrepancies are limited there.
No, the other dying declaration, as you said, better ticket will not.
11 टा
ତାପରେ ତା ଦେହରେ ବି ଲେଖା ହେଇଛି ନା
ଆଜ୍ଞା
ତ ମୋ ପାଇଁ ଦାୟୀ କିଏ ସୁଆଂଶୁ ଶାଶୁ ନାଁ ବି ଅଛି
ଆଜ୍ଞା ଅଛି
ଅଫକୋର୍ସ ସେ ଯୋଉ ସ୍ପେସିଫିକ ନାହିଁ
ନାହିଁ ଯେ
କିଏ କଣ ରୋଲ ନାଁ ଅଛି ନିଆ ଲାଗେ The only thing is that what about the other persons?
Other persons the brother-in-law, nonandi.
ନାଇଁ ସ୍ୱାମୀ ଅଛି
ସବୁଟା ସମସ୍ତେ କନଭିକ୍ସନ ହେଇଛନ୍ତି all are
bail କଥା
all are in court all are in court
Nobody has no application. We don't dwell with the doctor. We don't dwell with the doctor who recording the driving.
No, she is happy because she is a lady. 18 ବର୍ଷ 5 ମାସ ଖଣ୍ଡେ ରହିଲେଣି ଯାହା ଜଣା ପଡୁଛି ଆଉ ଘରେ ପୁଅ ସ୍ୱାମୀ ସମସ୍ତେ କଷ୍ଟରେ ଅଛନ୍ତି 8 ବର୍ଷ 5 ମାସ ହବ
8 years 4 months 3 days it was October up to 13/10 ଆଉ ମାସେ ଦେଢ଼ ମାସ ବେଳେ 8 ବର୍ଷ 6 ମାସ ହେଇଗଲା ପାଖାପାଖି it was about
What about this Gibbon? Who is he?
ସେ ନଣନ୍ଦି ଆଜ୍ଞା
ସେଗୁଡା ପଢୁନି
married by considerable lady
IA number 2690 of 2025. This is an application for bail. Land Council for the petitioner submits that the petitioner is a lady and she is the mother-in-law of the deceased and is judicial custody for more than 8 years. And there is no chance of early hearing of the criminal appeal in the near future. And the case is based on mainly on the dying declaration of the deceased, in which the name of the petitioner finds place. Submits that since there is no chance, the bail application may be favorably considered. If there is no chance of therefore the bail application may be favorably considered. Land and Council for the state drew the attention of this court to the dying declaration made by the deceased, which is recorded not only in the wedded ticket but also in
Exhibit 8,
but also in Exhibit 8 by the doctor. Doctor na ki
Titin doctor, yes, madam. Titin doctor.
in presence of the executive magistrate. In view of the available material on record, while not inclining to release the petitioner on bail and merit, but taking into account the fact that the petitioner is a lady and about her custody period, we are inclined to release her on interim bail for a period of 3 months. Yes. After we place and after 3 months, you will produce the surrender certificate with legible CRLA number 654 of 2017. Yes, next.
Item 20.
Yes, Mr. Singh. We are saying it is your matter. Yes. Yes, nice. Singh ko na chilana. Surrender certificate not filed. Yes, single appellant. Single appellant. Yes. So you are granted bail by order dated
Yes, that is 21/6/2024.
And there was a direction to file the surrender certificate. What happened? Surrender कलेनी ना नहीं
हाँ सर
कहीं हमें केमती जाने हाँ इनविटेबल 21 it is directed so on so bail pending so on
21 साल लगे
3 months
हाँ हमें डायरेक्शन थिला जदी 27 सेप्टेम्बर 2024 भितर सरेंडर न करिवे ताले एनबीडब्ल्यू इश्यू हबो
केबे सरेंडर करते
but he could not surrender in time because of lack of communication with the lawyer. That is the whole problem. That is that I
तमन से बाहर अछि
नहीं भी से बस संडे
हां
संडे ऑलरेडी कर
केबे सरेंडर सर्टिफिकेट कहीं
अच्छा we are taking the instruction लेखन the IA number 2890 of 2025. This is an application for bail. It appears that this court had order dated 21/6/2024 granted petitioner bail, interim bail, and directed specifically to him to surrender on or before 27th of September 24. Failing which the learning trial which was directed to take appropriate steps, including issuance of non-bailable warrant of arrest to apprehend him. When counsel for the petitioner submitted that the petitioner could not surrender on the date fixed, but at present he has been taken into judicial custody. However, since no surrender certificate has been produced by the land counsel for the petitioner, let a report be called for from the land and trial court regarding the status of the appellant, and for such purpose the file be placed before the land and register judicial, who shall send an email to the land and trial court, and the report be produced by so and so by pursuant to by 15th of December 2025, and matter will be listed on 17th December 2025. Yes.
Item 21.
Yes, madam.
The appellant has been convicted under 302 for life, my lord.
Single appellant.
Yes, my lord, single appellant. My lord,
What is your period of detention?
my lord, more than 11 years, my lord.
अच्छा custody certificate टा देखौची
Custody certificate, my lord, last time your lordship has directed the state council to produce the certificate. Custody certificate.
Custody certificate is there. So whether your bail application was earlier rejected?
My lord, actually, my lord, that special bench was sitting, my
Please,
lord, and I prayed for time, my lord.
1912.
Instead of time, it was on merit, it was rejected.
19/12/24, your bail
Yes,
application
my
was
lord, that was
rejected.
my lord, that was a special bench, my lord, that was conducting the matters, my lord. I have prayed for time, my lord, instead of time, my lord. My lord says
Nothing has been written there, ma'am. So please don't go. We're not entering into that. But fact remains that it has been written that there is dying declaration, and it's a case where 3 ladies have been set
yes, my lord,
fire
but
and they have lost their life.
my lord,
And so
my lord,
how
the doctor's evidence, my lord. 2 doctors, my lord, 18 and 19 PW.
it's a case of triple murder.
Yes, my lord.
So
The cause, my lord, cause of death is due to burn injuries, my lord. That's all. Whether it was, and the son of the deceased mother and 2 sisters, my lord, PW9, my lord, his
you see
evidence is important, my lord.
the bail application was rejected
1 year back,
last
my lord.
time on in the year 2024.
Yes, my lord.
19/12/24, even a year has not passed. So you are keeping it to January. Consider.
My lord.
January, let's go. January 20 business. Art C cost like that. Next.
My lord, date.
Item 22.
2026 से evening ready.
My lord, blessed one.
से date वड़ा का diary ये करी
My lord.
Yes, next.
Your lordship, in item 22, I prefer an adjournment on behalf of Mr.
What is your good name?
N.K. Pradhan, your lord.
Mr. N.K. Pradhan, Land Council for the appellant.
Yes.
6 for an adjournment. Eta छुट्टी पर नहीं यहाँ है ना? Xmas holidays for us. Yes, next.
Your lordship, any
Item 23.
Evening रे देखी देवे High Court website रे. The diary देखी के नहीं date हवो तुनु evening रे देखी देवे date पाइजी है ना? Yes, and this should come with this CRLA number 355 of 2013. Yes, next.
Item 23.
Appellant has been convicted. 02.
Ma'am?
From the informant.
It's a POCSO case notice was issued.
Okay.
Thereafter, say engagement was given.
Hand over a brief to him.
No, that has been given.
You have given.
Everything is given.
You are ready?
Yes.
Well, that appellant in custody for about custody certificate earlier occasion, custody certificate was called for. Well, is in custody for about 11 years. And the appellant was granted bail by the Honorable Court.
Rape and murder case.
My lord.
What are the materials against you?
Material, my lord, is my lord last seen.
Victim is 17 years.
Trial court has my lord taken into account. My lord, during trial also considering the evidence, this Honorable Court has granted bail.
No. How many years you are in custody?
Altogether 11 years, my.
Oh, अच्छा ठीक है मैडम फोन दो कौन मटेरियल अच्छी कहले
It is that the deceased is a minor and she was also pregnant.
Deceased was minor.
24 weeks.
Item number 24 रे
Yes, madam. I think meantime conduct certificate as
adjournment
conduct certificate and custody certificate may be called.
अच्छा Where is this? Have you filed the
Appearance will file with the registry.
already filed or you?
We will file.
Acha, it is stated at the bar that Mr. Devasish Panda is supposed to enter appearance for the appellant and he will file wakalatnama by next week. Like
That's memo of appearance.
Memo of appearance by next week.
Yes.
And the stop. IN number so and so. This is an application for bail. Land counsel for the state seeks some time to produce the custody certificate number 1, criminal antecedent number 2, jail conduct number 3. Hala? Next.
Item 25.
Mr. Das.
Minus.
Yes.
Take the years. Minus that. So the minus is directed to obtain the character certificate and the custody certificate and the criminal antecedent.
Ashchandi, Anishandi. Your other state council are not there today. So you are, why there is some problem with you?
Only Partha Sarthi is there, but due to his father is ill and I think he died. So that's why he left the.
Whose father died?
Partha Sarthi.
Partha Sarthi.
Oh.
Today. Then just take up it on some other day. These matters will come on Monday. So you should say that if you are facing difficulty, you should say that we are looking at you that there is no other state council and you are doing all these cases. So that is why we asked you. You should have said that this is the difficulty.
Father expired, you must tell.
All right. We'll take up this matter on.
Sorry, man. Item 12, the stay ration fine matter.